Okay. All right. Good evening, everyone. We're calling to order the Wilmington Town of Wilmington Board of Appeals meeting for April 22nd. It's approximately 7:05 p.m. I have to read this introduction because we're doing this via virtual meeting. Pursuant to Governor Baker's March 12th, 2020 order suspending certain provisions of the open meeting law under Mass General Law 38, Section 18, and the Governor's March 15, 2020 order imposing strict limitations on the number of people that may participate. Members of the public who wish to watch and listen to the meeting may do so in the following manner. Via WCTV Channel 9, Comcast, Xfinity Channel 37, Verizon Fios, and live stream WCTV.org. This meeting of the Wilmington Board of Appeals is being conducted via remote participation. No in-person attendance of the members or members of the public will be permitted, but every effort will be made to ensure that the public can adequately access the proceedings in real time via technological means. Members of the public who would like to listen to this meeting while in progress may also do so via telephone by dialing 1-646-558-8656 and enter meeting ID number 948-0131-9175, then press the pound key, and then press the pound key again at the next voice prompt. Members of the public attending this meeting virtually will be allowed to make comments if they wish to do so during the portion of the hearing designated for public comment. By following the steps previously noted, then press star 9 on their telephone keypad. This will notify the meeting host, which is Mr. O'Neill, that the caller wishes to speak. All callers using this feature will be placed in queue in the order that they entered the prompt. In the event that despite our best efforts, we are not able to provide for real-time access, we will post a record of this meeting on the town's website as soon as we are able. Okay. And I'm looking at the agenda. We have all members present. I'm going to take the first case on the docket. I'm going to call case 217, Echo Site Incorporated, map 79, parcel 31D, 4 Waltham Street, to request a continuance on the Board of Appeals May 17th, 2019 decision for the approval of a variance to construct a new wireless communications facility. Do we have a representative of the applicant here?
Kelly, that's Adam.
Yes, that's Adam Braillard.
Adam, how are you?
I'm fine. Thank you, Mr. Chairman and members of the board. My name is Adam Braillard. I am with a law firm called Prince LaBelle Ty. We represent the applicants, EcoSite and T-Mobile, with the installation operation of a wireless communications facility that we're proposing in town.
Okay, counsel, why don't you tell us why you're here, what you're seeking, and what kind of relief or whatever you're requesting from the board.
Sure, thank you. We are here in connection with requesting from the board a variance extension. This board approved a special permit variance for the applicants back in May 19th of 2019, which was then filed with the clerk's office on May 21st of 2019. And since then, the applicants have been working toward getting their approvals to develop the tower, but are not there yet. And I can go into detail if the chairman and the board desires.
I mean, if you're just looking for an extension, it's something we previously considered, then I would probably just suggest you tell the board what you're looking for, and
Sure.
we'll put it to the members to make whatever motion they deem appropriate.
Sure. Yeah, we're looking for a 6-month extension from May 2020. So that would be to November 21st. Under statute, the board has the authority to do that for that amount of time.
Okay. I'm going to conduct the meeting as closely as I can to the procedures I've done in the past, given the limitations of the forum. So I'll kick it back to the members of the board for any questions or comments from the applicant before I open and subsequently close the public hearing. Are there any members of the board that wish to address the applicant on this? Okay. I'm hearing none. Is there any member of the public that wishes to be heard on this particular application?
I haven't received a comment, Dan.
What was that, Jonathan?
I have not received any virtual hands raised for comment.
Okay. There's a little bit of a delay, so if I'm a little staggered, forgive me, because I want to make sure that what I say gets communicated out. But I'll do what I do at every meeting: going once, going twice, and gone. So I'm going to close the public hearing, and I'll bring it back to the board for any member who wishes to make a motion to grant the continuance as requested by the applicant.
Chairman, I'll make a motion. Jackie Santi. I'll make a motion for case 2-17 to extend the request for 6 months, a 6-month extension. Continuance on the, I guess just to continue their case for 6 months.
To grant the continuance on our previous decision for the approval of the variance.
Yes.
Okay, so we have a motion by Ms. Santini, as I had previously indicated to the board. Due to this particular format, we're going to have to do everything via a roll call vote. Do I have a second on that motion?
I'll second.
And who would that be?
Ray Lepore?
Ray. Okay, we got a second by Mr. Lepore. Now, all those in favor, and I'll go down. Ms. Santini, aye or nay?
Aye.
Mr.
Aye.
Syracuse, aye or nay?
Aye.
Mr. Lepore, aye or nay?
Aye.
Mr. Barletta, aye or nay? And then aye for myself, so it's unanimously granted. Thank you, council. We appreciate your patience.
Thank you very much. Everyone stay safe and healthy.
All right, have a good night.
Take care. Thank you very much. Everyone stay safe and healthy. All right, have a good night.
Now, the next matter on the docket that I'm going to entertain now would be case 520, and that would be the case petitioners Jarrett Belter, map 21, parcel 8E, 9 Cushing Drive. And the request is to acquire a special permit on 6.6.7.7 for the groundwater protection district. Do we have Jarrett Belter or a representative here ready to go?
Present.
Who? Oh, hi,
This is
Jarrett.
Jarrett.
How are you?
I'm well, thank you.
I'm doing all right. Why don't you let us know what you have and what you're speaking for?
Sure, we're seeking permission to install an in-ground pool. We had engineered drawings done for the property. When the property was built, there was a 1,000-gallon dry well that was installed, which wasn't included on the original groundwater protection various coverage summary. The addendum was done to the drawings and reviewed by the town engineer as well. The downspouts for the house drain into that dry well, which brings us under the 15% required impervious area coverage down to 12.1%, as noted by the drawings.
And I do have your submission here, and I do see that. Ms. Malatesta, do we have anything formally from the town engineer on this?
We do. So I can read it into the
Why don't
infiltration.
you just do it for the sake of brevity? Why don't you just read in what the engineer said on it?
Sure. The infiltration best management practices that exist on site are adequate and meet the groundwater protection district. Thus, the engineering department recommends a special permit.
Gotcha. Okay, I'll kick it to the board. Does anybody on the board have any questions or comments on this application before I open the public hearing? Nobody? Okay. So I'm going to open up the public hearing. Is there any member of the public that wishes to be heard on this application?
Mr. Chair, we do have a caller who wishes to speak.
Okay. How do
I'm
you?
gonna unmute them now.
Okay, thank you. And what I'm going to ask is everybody throughout the duration of the meeting, any resident who or interested party who wishes to speak, please identify yourself by your name and your address, please, for the record.
I'm waiting to speak on a different item.
Okay, this is going to, what we're discussing now is case 520, Jared Balter, map 21, parcel 8E, 9 Cushing Drive, and it was a request for a special permit under the Groundwater Protection District. Is that what you want to be heard on or no?
No, I'm waiting for a different item. Thank you. I'm
Okay.
sorry.
That's okay, no problem. Well, then just, Mr. O'Neill, if you can just, I don't know how technologically we can put her back in queue so she can speak on the desired item that she wants.
Taken care of.
Okay, so is there anybody else that wishes to speak on this particular application?
We do not have anyone.
All right, going once, going twice. I'm closing the public hearing. I'm going to kick it back to the board. Would anyone like to care to make a motion on this particular application?
I'll make a motion to approve case 5-2, 9 Cushing Drive to acquire special permit 6.6.7.7 for groundwater protection district.
Okay, we have a motion by Ms. Santini. Is there a second?
I'll second.
Who's that?
Ray Laporte. Yes.
Okay, we have a second by Mr. Lepore. All those in favor, Mr. Barletta, yay or nay? Yay. Ms. Santini?
Yes.
Yes. Mr. Siracusa?
Yes.
Mr. Lepore?
Yes.
And then myself, I'm voting yes as well. So that's unanimously granted. Thank you, Jarrett.
Thank you, board.
All right, take care. Okay, now the next matter, and just for the edification of the audience, I'm taking the matters out of order on the agenda based upon the brevity and quickness that we can get these folks resolved. So the next matter I'm going to take is the 4th of July committee, case 620, Wilmington 4th of July celebration, map 52/66, parcel 38/1, the Swain School lot, to acquire a special permit under section 4.1.9 for a carnival to run from July 1st, 2020 to July 5th, 2020. Mr. Grant, are you there?
I am, Mr. Chairman. Thank you.
How you doing?
I'm all right. Desperate need of a haircut, but otherwise all right.
Join the club. At least we have it. Go ahead. What do you, Scott? Why don't you outline what you're looking for this year?
Sure.
I will say, as a general observation, does everybody hear me?
Yes.
Okay. I just will say, as a general observation, and it probably goes without saying, that I'm not sure what the situation is going to be like for this particular date. I don't know if it's something that would benefit from being kicked over to our next meeting. I'm going to leave that in your hands. But I think if we grant it, and then at some point you're going to have to get it continued to a date later in the summer or even in the early fall, I guess you'd have to come back. You're the applicant. I'm going to let you do what you want to do, but obviously you understand the limitations we're all operating under.
Sure. And obviously we have some planning that we have to solidify at this point. We've been in contact with town officials. Obviously, we're all aware of the pandemic and we're keeping on top of things and how it affects our celebration. We're meeting on May the 5th and anticipate making a decision one way or the other on that evening. And I don't think a celebration at a later time in the year is viable just based upon the availability of the carnival because they're booked elsewhere.
I get it. And the only reason I raised that, Scott, is that I've just read through news sources that some folks are kicking over the celebrations to like September or whatever, but. So, okay, I get what you're saying. Might as well get it in case things, hopefully things turn out well. So tell us what you're looking for this year.
Okay, and thank you, Mr. Chairman. Please bear with me. This is very repetitive of prior years, but you don't mess with success. We haven't changed much of what we do. So the applicant, Wilmington 4th of July Celebration Incorporated, is requesting the issuance of a special permit under 4.1.9 of the zoning bylaw, which provides that in all districts, open-air carnivals on premises owned by a municipal or religious organization or private lodge or club, may be authorized by special permit from the Board of Appeals, provided that such uses are limited to appropriate restrictions on the number of days and the hours of operation. The planned dates for the 2020 celebration, which by the way is our 40th, are Wednesday, July 1st through Saturday, July 4th, with a rain date of Sunday, July 5th. The carnival itself is proposed to run as follows: Wednesday, July 1st from 6 to 10 p.m., Thursday, July 2nd from 6 to 10 p.m., Friday, July 3rd from 6 to 10 p.m., Saturday, July 4th from 12 noon to 10 p.m. If the rain date of Sunday, July 5th is necessary, we'll run from 1 p.m. to 10 p.m. with the carnival. One change this year, we're planning on 2 nights of fireworks to commemorate our 40th celebration. That'll be Friday, July 3rd and Saturday, July 4th. There won't be a rain date for the July 3rd show. It'll be subsumed, if you will, into the July 4th show. If the July 4th show is rained out, we then plan to shoot on Sunday, July 5th. The layout of the key components of the celebration, including the carnival, is proposed to be the same as the layout utilized since 2016. That being participating nonprofit organization booths on the town common, the carnival in the parking lot next to the 4th of July building, fireworks launched from the grass practice field situated on the Wildwood Street side of the high school campus. It's once again anticipated that additional events such as that have traditionally been a part of the celebration, including concerts, meals, games, Family Day on July 4th, will be conducted as they always have been, predominantly on the town common. As has always been the case, committee members and town officials, including public safety officials, will work together to address factors including vehicle and pedestrian traffic, noise, lighting, etc. Parking will be available at Wilmington High School, and it is anticipated at St. Thomas Church, Middlesex Avenue. Will be closed to vehicular traffic during all events. Shuttle buses will be run from locations throughout Wilmington on the night of the large fireworks, whether that's the 4th or the 5th. In terms of specifics for the carnival, the following long-standing rules will once again be imposed upon, and this year it's Cushing Amusements once again. The Wilmington 4th of July Committee will have contractual control over the sound levels of music emanating from carnival rides, and will instruct the vendor to disconnect all air horns and similar noise-producing devices. The carnival vendor will be required to provide the police department with the names and social security numbers of all staff members who will be assigned to work at the carnival while it is in Wilmington. This information is to be provided no later than 30 days prior to the start of the celebration, and background checks are conducted by the Wilmington Police Department, which has authority to deny participation by any carnival staff members. Carnival staff members are not permitted to stay on site overnight. One employee will be permitted to remain on site during the overnight hours to provide security. The carnival vendor will be required to provide proof of insurance satisfactory to the committee and to the town, naming both the town and the committee as insured parties. The carnival vendor will only be allowed to have large trucks into the common area and to set up and break down equipment between the hours of 8 p.m. and 8 a.m. In terms of the layout, subject to final approval by the fire department, it'll once again be designed to situate the trailered funhouse type attractions and equipment at that portion of the parking lot closest to the residences on Powderhouse Circle, due to the fact that they generate the least amount of sound and will provide somewhat of a buffer to the residences. The layout will be such that fire lanes providing access to all areas will be maintained. The carnival vendor will be required to use quiet run generators. In addition to coordinating traffic and parking along with members of the committee, police personnel will be within the carnival location at all times of operation by the carnival. The maximum number of concession stands and midway games situated in the carnival will be limited to 12 to 14. In terms of the number of rides, this will be the 5th year at this location. The fire department and the state inspectors now have 4 years of experience with the site and are best suited, in my opinion, to determine the number of rides and attractions to be placed on site. Just as we rely on the health department to oversee food preparation and service during the celebration, and the police department to oversee crowd management and public safety, we request that while a balanced number of kiddie rides and major rides will be maintained, final determination as to the number of rides be left to the fire department and the state inspectors. In terms of the fireworks, responsibility for siting and staging of the fireworks setup falls upon the Town of Wilmington Fire Department in conjunction with the State Fire Marshal's Office. The planned location, as I said, is the grass practice field on the Wilmington High School campus. State regulations mandate the maintenance of a clearance zone equal to 70 feet for each inch of shell diameter being utilized. The largest shell anticipated to be used during the big show will be 5 inches, and therefore the clearance to be maintained is 350 feet. The perimeter will be demarcated by snow and metal fencing, which are permitted barriers under the regulations. Emergency vehicle access will be maintained and fire equipment will be staged at the launch site prior to the commencement of a launch. As is always the case, a member of the fire department will be at the launch site for the beginning of the setup of the fireworks display through the post-launch site walk. Fireworks personnel will conduct a post-launch site walk and first light site walk as required by state regulations.
I guess the only question that I have for you, Scott, is that I'm looking at your application. It says the carnival vendor will be required to maintain an equal balance of kiddie rides and major rides.
Correct.
But you've added in your presentation the provision that is subject to, I guess, local officials. But I guess all things being equal, if it's left up to the committee, are they going to have an equal amount of kiddie rides and major rides?
Yeah, the total final number, or the total number of rides, would be under the auspices of the fire department. We're requiring an equal number.
Okay.
Or last year there were 15 and it was eight major and 7 kiddie.
Right, because I don't think the town officials probably have no interest in telling you how many kiddie rides and major rides you have, right?
No, they don't have any interest whatsoever. It is our practice, and certainly in working with this board, that we want to maintain an equal balance.
How many rides did you guys use last year?
15.
But you had the authority to do 16, right?
I believe we had authority to do 15.
No, 15. Actually, what I would do is, because I have last year's, it was no more than 15 rides, but what I would do if I'm making the motion, I'm going to read exactly what it was last year, and that was approved, and it was basically, the date, the hours and the dates as specified in the narration of the application with no more than 15 rides. No, I mean, I'm just saying, like, what.
I want to let the whole board speak in whatever audience, but I understand you're saying that you agree with the motion that you made last year.
Yes, that's what if it was me, I would be doing the same thing.
Okay. Well, I want to open it up to the whole board. Does anybody else have any questions of Scott, or comments on the application before I open a public hearing?
Yeah, I have a question. So in regards to the additional day of fireworks on July 3rd, the coordination of the fire department, and is that additional labor, additional cost to the town, as opposed to last year?
It would be.
So how is that compensated?
I presume it would be.
So how is that compensated? Would that be additional costs charged to the taxpayers in the town, for July 3rd, or is it picked up by the 4th of July? How's that work?
The committee itself doesn't pay any of the town wages.
So that's an additional cost that it was for last year, right?
Correct.
So how much more difference is it?
That you would have to ask the town manager. My apologies.
Now, Mr. O'Neill, is the town manager in on this meeting or no?
You gotta unmute yourself.
He's listening but not participating.
Okay. Is there a way for him, if he wishes to answer any question posed by the board or any member of the public, to be able to chime in?
I can get in touch with him and see if he's will indeed participate at some point, but not right now.
Okay. You might want to just send him a text, because I mean, if there's a member, you know, if he's here and he can answer a question, and it's a way that he can do so, that might be helpful. But so why don't we table Tom? He's reaching out to the manager now. Do you have any other questions of the applicant? And then when Mr. Hull is maybe available, he can answer your first question.
No, I had no other questions, thanks.
Okay, so why don't we hold off on that? And I'm sure Mr. Hull is probably going to endeavor to get into the meeting. Does any other member of the board have any questions for Scott?
Yeah, I have a question. Jackie Santini. So if it doesn't happen this year, then the funds that were for this year, it will be great for the following year, and then you'll have ample amount, or what happens with the funds from this year? Does it just get rolled over to next year?
You talking about committee funds?
Yeah. The funds that you're getting this year, does it get rolled over just to next year?
Jackie, I think, and Scott, you can correct me because you obviously know the answer to this question, but I think that the committee has their own budget, which is not subject to any type of stricture or control by the town. But I do believe that there's an appropriation that's used to offset some costs of the celebration. Are you asking, Scott, what happens to their funds or the town funds?
Well, actually, I'm kind of thinking ahead. If it doesn't happen, and right now, well, if it does happen, you're saying that the town is going to incur costs from the fire department or for the fireworks, right? So if it doesn't happen, then following year, hopefully some money's put aside so that in the event so that the town won't get incurred, won't have any additional expenses, right? So I guess I'm saying, if it doesn't happen this year, is there going to be an amount set aside so that, like this year, you're saying that the town's going to incur some additional costs on the fireworks, that hopefully next year maybe that could be avoided?
Mr. Chairman, again, I'd have to defer to the town manager on that. And as you mentioned, we have our own budget. And if we don't spend money on fireworks and events and games this year and bands, so forth, then the budget will remain stagnant.
Yeah, I kind of agree with you, Scott. I mean, Jackie, they have a budget. It's a private organization that they have. You know, I believe it's a nonprofit organization. They have their own budget, and if they don't go forward this year, then maybe they'll be flush for next year. But that's nothing that we have to do with. If you're asking what happens to the town appropriation, which is kind of akin to the question that Tom raised about, you know, how the town's expenditures for the celebration, that would probably be better directed to the manager.
Okay.
And maybe Mr. O'Neill, if we get the manager in here, he can knock out both of those questions. But we'll hold that, okay, Jackie?
Yep.
Okay. Is there any other member of the board that has a question of Mr. Grant?
I just have a comment, Dan.
Yep.
So I'm okay with allowing additional or more rides than they had last year. I think the prior year, we increased last year from the prior year. And I think that it's okay, because I think I made the same comment last year that, this is a year by year basis. If everything goes smooth from one year to the next year, and we incrementally increase it to a point that's reasonable, I'm okay with that. I just don't like the idea of leaving it up to some town, the fire department to lay it out, because I think the fire department's going to ultimately ask the carnival vendor to propose something, and I think it needs to be somehow managed so that it's just not a free-for-all.
Well, I think, and Scott, you can answer this question. I think that in the past, the amount of rides that we granted the 4th of July committee the authority to exercise hasn't always, they haven't always used the amount that they were granted. I don't know if they ever went, I don't think that they ever said that there were more than they were ever allowed. I think in a couple of years they maybe didn't use the amount that they were granted. But I do think that we should probably at least direct the 4th of July committee to have a number. I mean, especially given the situation. I mean, I'm sure that I don't think the carousel horses are 6 feet apart, so there are probably some rides that might be compromised. But again, I'll leave that to the 4th of July committee chairman to talk about. But I know that in some years that we've given the authority to use more rides than were actually utilized.
I don't know that to be the case. I'm not refuting it, but I can't believe any carnival vendor would bring in fewer rides than were authorized. And just in terms of the fire department making the layout, the carnival vendor every carnival vendor does this on a week-to-week basis. They know the spacing, they know how many rides they can fit, and annually we require them by June 1st to provide a layout and plot plan to the fire department. So the fire department has final approval, and frankly, I'm not qualified to do it. It's the fire department and the state inspectors who are qualified to do it.
Okay. I personally think that it's a good practice to, at least on the application, give the amount of the rides rather than leaving it in limbo. But I'm only one person, so.
Well, so my point to that is that when we had this conversation last year, it was fine to do, and that's why I wanted to read that there was like designated, I mean, that it's like laid out 7 rides designated for adult rides, 7 for kiddie rides. And I think if last year went so smoothly, I'm just, my feeling is I would do it the same way, status quo. And it actually was up to 15 rides, but Mr. Grant even said 14, but I'd even go with exactly what was last year. And it's basically specifying kiddie and adult rides.
All right, that's a fair comment. Is there anybody else on the board that wishes to opine on this particular application before I open up a public hearing?
I'll just reiterate what I said, is that I'm okay increasing the number of rides, because I think it has been a very open process that the 4th of July committee has gone through over the last number of years. I think they've done it responsibly. I think it's okay to increase the number of rides, but I agree with you, Dan. It can't just be open-ended with no limit put on it. I think if Scott came back and said, we had 15 last year, we want to go to 17 this year, I would have no problem approving that, because ultimately it's going to get approved by the fire department, but I wouldn't want to see it go from 15 to 21 rides. And that's the only thing that I would want to avoid, and that's why I wouldn't leave it open-ended.
I think the physical site of the location is probably determines how many rides they have. And given the current circumstances, if it were to go forward, and I hope it does, if it were to go forward, I think that there may have to be some type of an adjustment downward practically, if not, if not legally. But I agree with you. I think that there could be a number put in the permit so everybody knows what we're looking at.
Mr. Chair, I believe Mr. Hull is on the line now if the questions want to be repeated.
Yeah, you know what? Rather than, I don't want to characterize the questions on behalf of the members. So why don't you bring them up? And then Tom, we'll have you ask your question first about what, I think it was regarding the additional costs for the second night of the fireworks. And then Jackie, will go to you and you can address, what happens to the excess and the appropriation from the town if the thing doesn't go forward. Is that fairly characterized?
Yes.
Yep.
Okay, why don't you bring them on up, Mr. O'Neill?
Mr. Hull, you there?
Yes. So with regard to the cost for the second night of fireworks, the approximate cost for the fire department is about $1,500.
Can you speak up? I can't hear you. Can you speak up, please?
The cost for the additional night of fireworks.
Oh no, we lost him.
Yeah, he just dropped.
No.
Okay, can you hear me now?
Yep.
Okay, so the cost for the additional night of fireworks for the fire department is roughly $1,500 for that additional night.
Okay, does the town manager have a problem with using the additional funds?
I mean, $1,400 to $1,500, we can certainly afford that. As you know, there's an appropriation each year at town meeting in the amount of $50,000 that has been used to defray the costs associated with the fireworks.
Okay, does that answer your question, Tom?
So what's the total cost for the town for the 4th of July celebration?
I don't have the last year's figures in front of me, but I believe it was just over $50,000 in overtime costs between the fire department. The police department is the most significant part of that, and then DPW to some measure.
So does this mean this is going to go over the appropriation expended?
It will go over the, I expect it may go over the $50,000 that was appropriated by town meeting, and then the balance is taken care of through the overtime budgets in the respective departments. But I don't think it's going to be a significant amount above the 50.
So I ask again, does the town manager have a problem with that?
I do not.
Okay, thank you.
So my question is, if it's not used this year, is it saved for the following year?
If the funds in that $50,000 appropriation from last year's town meeting are not used this year, that money goes back to the town's general fund. So it goes back into the town's account, so to speak. It can't be used for any other purpose, and then the money would have to be raised and appropriated again at this town meeting if there was going to be an event next year. So it does not, the money does not carry forward into the next fiscal year.
But is it appropriated if it's not used? Then it just stays in the account and it's not going to get used for something else, is it?
No, so at the end of the fiscal year, any balances that remain in budgets that are not, where there's no obligation, all of those funds go back to the town's general fund and ultimately become part of free cash. So they can't be used for any other purpose. They just get returned to the town's general fund.
Okay.
You all set, Jackie?
Yeah.
Is there any other member of the board that wishes to ask a question before I open the public hearing? Okay, so we're gonna, Mr. O'Neill, fire it up. We're gonna open up the public hearing. And before we do that, I just want to let everybody know, we're dealing, everybody knows we're dealing with a difficult kind of a situation here, and it's a little, we're constrained to a certain degree. So I'm going to let everyone who wants to speak on anything tonight have their say. But as I enunciated yesterday, I'm going to limit everybody to roughly 3 minutes. If you're making a cogent point or there's a question that's being answered that runs over, I'm not going to, that's fine. I'll let it bleed over a bit. But everybody's going to get to speak. Everyone's going to get to speak one time, and everyone's going to have roughly about 3 minutes. So with that being said, Mr. O'Neill, can you queue up the public comments?
Sure, we don't have any right now. I just want to remind anyone joining in by phone that you can hit *9 to raise a virtual hands that will indicate to me that you wish to speak. We do have one individual who looks like has a question. I'm going to unmute them now.
Okay, and again, just to remind everybody, we see phone numbers, we see no identifying really information. I would just ask that anybody that speaks, when they get their one shot, that they give their name and their address, please, for the record.
This is number 6358.
Okay. Am I on?
You are.
Suzanne Crooker, 135 Middlesex Avenue. I am in a butter. And when we first saw this application, we were pleased to note that the number of hours planned for the carnival this year had been reduced from earlier years. It unfortunately did not include a layout or specific number of rides, although Mr. Front has just stated 12 to 14. Since the vendor did not use all the rides allowed in the petition last year, and the petition last year was amended last year to allow 15 rides, there seems to be no reason to leave this open-ended or to allow more rides than were previously used. And last year, the petition had 14 rides used, and on only one night were 15 used. Okay? Second, another note from last year, the vendor removed rides the day after the last night of the carnival up to and past midnight with loud exhaust and engine brakes working. This was a clear violation of the time stipulations in the agreement for setup and breakdown. What recourse do we have if this infraction occurs again this year? Third, now to the current situation. Governor Baker has closed all schools, public and private, until September 1st. His decision was based on information gained from consultation with school boards and superintendents around the state. In light of all the other events that are being canceled around the state due to the COVID-19 pandemic, we think it would be reasonable for the petitioner to withdraw the application this year. If this is the only event that occurs in the area, then we would be a magnet for people from all over to gather here. If the petitioner does not withdraw, then we ask the board to deny the permit for this season. If this board does not deny the permit, then there need to be updates to the plan that has been submitted regarding how the event will be held with regards to appropriate social distancing, sanitation between customers, limiting of crowd orders that may continue to be imposed by the governor. Would it be prudent for the Board of Health to make recommendations? The Wilmington Little League is canceled for spring and will confer with the Board of Health for approval and guidance about any opening in the summer for softball and baseball. Thank you.
Thank you, Ms. Crooker. Scott, you want to address her points?
Certainly, and I share the concerns, and as I expressed 15 minutes ago, we're meeting on May the 5th after having consulted again with town officials on whether or not to proceed. Boston has not canceled their celebration yet. The town of Wakefield has, Somerville has, and I can find 5 or 6 others nationally that have. If I had to guess today, we will not be having this celebration. However, we need this special permit in place if we are going to have the celebration, and we certainly will be discussing every last element of this if we are going forward with the Board of Health and every other town official with input into the celebration.
Okay, do you want to address the other questions that she had, or? I mean,
cer-
I think
cer-
she probably used up her close to her 3 minutes.
Yeah, I mean, certainly the trucks after midnight, this is the first I'm hearing of it. And I will address it, and I will address with the town manager any necessary enforceability, whether that's police or otherwise, but I'm very disappointed to hear it. And I will certainly address it with the vendor.
Okay, I think that those were the major points that she had, but the board can obviously, follow up on anything else. Again, we're dealing with a bit of a situation here as far as technology, but okay. Is there anybody else that wishes to be heard on this particular matter?
We do not have anyone, Mr. Chair.
Okay, so we have no further public comment. I'll go in once, going twice, gone. The public hearing is closed. I'll then now kick it back as is my usual procedure to the board. If anyone cares to have any further follow-up questions, comments, or make a motion on the application.
Actually, I have a comment, or I'm just curious. If there was movement or of some sort, why wouldn't the police know about that? I mean, at midnight, that seems a little strange. Why? I thought that they were part of, aren't they patrolling or somehow?
Well, if it would have been, in defense of what Ms. Crooker said, and obviously I don't have any firsthand knowledge, if it was after midnight on the last night, the police may not have been there at that time. But rest assured, I'll address it.
And she'll let you know, Scott. I probably wasn't even here or awake, but I'm sure that what she says is probably accurate, although I can't speak to that directly. Anybody else?
I'm sorry, Mr. Chairman. I have no reason to doubt her. I'm just surprised that if it did happen, I'm hearing about it 10 months later.
Okay, I hear you. Maybe the lines of communication between the 4th of July committee, not just you, but maybe the lines of communication. I mean, clearly she's an interested abutter. I know she's an interested abutter. Maybe the lines of communication should be opened there. But that, that's a question for another day. Is there any other?
They always have been.
Okay, good enough. Fair enough. Anybody else wish to speak about this or make a motion?
I'll make a motion with one comment. I can appreciate that if the committee actually, I know they'll do the right thing. If it's not something that was meant to be for this year, I'm sure that, as a committee, it will work out that you will cancel or do the right appropriate thing. So I'm going to make a motion to approve the special permit for case 6-20, the Wilmington 4th of July celebration, to acquire special permit 4.1.9 for the carnival to run from July 1st, 2020 to July 5th with the dates and hours as specified in the narrative of the application, with no more than, I'll say 15 rides max, with 7 rides designated as kiddie rides, 7 rides being designated as adult rides, and the final ride to be designated by the applicant as either a kiddie ride or an adult ride, with set up beginning at 7 a.m. and equipment dropped off to be so the drop off would be, is that the day prior, which June 30th then, if that by 10 p.m. That's my motion.
Okay,
Mr. Chairman, if I may.
Sure.
I know last year we did have somewhat of a change in the hours for the drop off of equipment. I'm proposing 8 a.m. to 8 p.m. But if June 30th is the day for equipment to start coming, we can't open till July 3rd. So If we're opening on a Wednesday, it would have to be the Sunday before that they could start coming in.
And what hours, Scott, would the committee be requesting that occur
8 a.m. to 8 p.m.
on that Sunday?
It's,
Any day, you know, any day that we're not operating, but setup, breakdown, heavy truck traffic, 8 a.m. to 8 p.m.
Okay.
I will amend my motion to, it's actually June 28th, 2020, which is Sunday. 8 a.m. to 8 p.m. for setup. And
For the
drop
commencement of setup, please.
for the commencement of setup.
Okay, we have a motion as stated. Do we have a second on that?
I'll second that.
We have a second by Mr. Siracusa. I'm going to go down through the roll call. Mr. Barletta, yay or nay?
Yay.
Was that yay? I couldn't hear you, Tony.
Yes.
Yes, yay. Ms. Santini,
Yes.
Mr. Siracusa,
Yes.
Mr. Lepore,
Yes.
and I'm a yes myself, so it's approved. Good luck, Scott. I really, truly hope everything goes forward. I want everything to get back to normal.
I hope so. This is, for me and a few others, our last year, so we're certainly hoping it comes together.
All right, God bless.
So, thank you, everyone.
All right, take care.
You too.
Okay. Now the last item on the agenda is case 718, Bettering LLC, map 89, parcel 6A, 362 Middlesex Avenue. It's a request of to request an accommodations under the Americans with Disabilities Act, the Fair Housing Act, and the Rehabilitation Act to allow the construction of a 48-bed rehabilitation facility at that site. And I just want to make sure that we have all the players here. Attorney Bobrowski, you're here.
Yes, Mr. Chairman.
Okay, I see we have Town Council, Mr. Silverstein here. I see we have our other council, Greg, Lenny, good to see you. Is there, do we have the applicant here? Mr. Nealand, are you here? Or are you just, Attorney Bobrowski, are you just going to speak for Mr.
Yes.
Nealand?
I'm here.
Okay, Mr. Nealand. So do we have everybody present that we need to move forward for the first part of this hearing? And I'm not talking about public comment. I'm talking about the actual participants. Is everybody here?
Yes, Mr. Chairman.
Okay. Okay, Attorney Bobrowski, why don't you let us know how we got back here? Like what's going on? I mean, we heard this a year ago. I understand there was a court procedure. I understand that it came back. We voted to rehear it, but if you could give us an overview, and I'm also going to want to hear from our council, all of them, as to how we ended up getting here and what you're seeking.
Thank you, Mr. Chairman. For the record, Mark Bobrowski, my office is in Concord. I represent Bettering LLC. With regard to your question, it's been a long and winding road. We first found ourselves removed after filing the complaint in Middlesex Superior Court to Federal District Court. At that point, after the initial paperwork settled the dust, the matter was set aside for mediation by Judge Magistrate Bowl. And after one session that I recall, if not two, the parties were set loose to try to come up with a reasonable accommodation remand request, which ultimately we did roughly around the end of January of this year. The court then issued a remand order to both, to the ZBA. We also asked the planning board to take action. The planning did take action on our reasonable accommodation request earlier in the month of March. Unfortunately, it was 1 week before your meeting in March. I think it was March 18th, and everything was canceled at that point in time due to the COVID-19 crisis. So we've waited patiently for everyone to get familiar with this technology, and here we are on April 22nd. The court's initial remand order said that the matter was supposed to be resolved and a decision filed in the office of the town clerk no later than April 1st. Obviously, nobody's fault. We're patiently trying to do the right thing. and we find ourselves here tonight seeking a reasonable accommodation from the Zoning Board of Appeals. Before I end my description of where we are, I want to just point out that I did send a letter to the board certified on January 31st, 2020, and in it, it goes into great detail on the nature of the reasonable accommodation request. I'll just hit the highlights because other people may not have seen this document yet. What we are essentially seeking is a reasonable accommodation on two fronts. Number one, the plan has changed, as Mr. Osgood will explain momentarily. It's changed in such a way that we no longer have a big cul-de-sac creating frontage for the project. Instead, we seek a reasonable accommodation as to the frontage requirements in the GB district so that we can come up with a better design for the project that should make for a better street view, and certainly the layout of the building will be better on the property as it affects the neighbors. The second reasonable accommodation request is as to the use, because the plan has changed and it's not the definitive plan that was approved by the planning board in 2018, I think. We no longer have a vested right to apply for a special permit under the 2017 zoning. So we're flat out asking for a reasonable accommodation as to the use. This detox center is a use protected under the ADA and the Federal Fair Housing Act amendments. And under those federal statutes, we seek protection from you tonight.
Can you tell us the changes in the project since the last time you were before us? Could you
Yes, I think Mr. Osgood is primed to do that, and I'll ask him if he would do so.
Yes, good evening, Mr. Chairman, members of the board. Ben Osgood, engineer for the project. Essentially, there are some changes that I'll outline. I don't know if, Kelly, you have the ability to put up the plans that we submitted, or I could share my screen. I have them here. I'm not sure how you want to do that.
We're at a bit of a technological disadvantage. I mean, I know, were these plans, were they who were they available to? Just the board?
They were part of the reasonable accommodation request I sent to the board on January 31st through council.
Okay.
And I believe in the certified letter as well.
Okay, Kelly, are they a member? Are they a part of the record?
They are.
Have they been available to the public?
No, they went to you for this meeting.
Right, but I guess my pardon?
If the public requests them and comes into the office or calls, I do give them copies. But it's not something that's on the computer available for them.
I understand. Has anyone come to the office requesting to view the plans at all?
They have not.
Okay. Well, then I think this is one of the situations we're dealing with this particular format. You know, since we obviously can't put anything up on the screen for people.
Mr. Chair, we can.
Oh, you can?
Yeah, Kelly's going to find the plans right now, and I'm going to have her share her screen.
Okay.
Osgood has them. He could do it.
Okay. While that's being done, can anyone articulate the changes verbally if we're waiting for the plans to be uploaded somehow?
Yes, Mr. Chairman, I can do that. So as Attorney Bobrowski said, the cul-de-sac was eliminated. So what that enabled us to do was to move the building towards Middlesex Ave approximately 30 feet. This also allowed us to move the septic system further from the back property line, which in turn moved the retaining wall further from the back property line and allowed us to put the line of trees down along the property line adjacent to the abutters. Those are the major changes. We've changed the septic system. With the additional room that we have, we were able to use a different type of system, a Presby system. So we don't need to use the entire back, corridor along lots behind us. So there's a septic system on the southwest side of the rear property. And then there's a reserve area on the northeast, I guess the north side of the property, instead of the septic going along the whole rear of the property. So there is fewer trees being cut for the initial construction, and the septic system area is smaller, so that it's, less development area for this proposal. The drainage essentially stayed the same. It's an underground detention system. There's a small pond out in the front now, a small, landscaped area that provides infiltration, it's kind of a bio pond, bio infiltration area. But other than that, the drainage stayed the same. It's still serviced by the municipal water system, and there's a hydrant out back. We've submitted the turning plans to demonstrate that the fire engine can still make it around the building. One change that we did make at the request of the police department was to make it essentially a circular access around the back of the building that would be one way. So the counterclockwise, when you park out in the back of the lot, you will not be able to kind of drive out clockwise around the building. You'd have to go out the rear of the building, go out the exit, which is towards Middlesex Ave. And I believe that those are the major items.
While they're setting up the sheet, Ben, I want to add two things, Mr. Chairman, that are also quite significant changes. Number one, the building itself in the original application to your board was parallel, if you will, to the rear property line, so that anybody who lived behind us was looking at the entire breadth of the building between their backyard and Middlesex Avenue. Now the building has been put on an angle on the property so that anybody to the rear will see a point of the building, and it'll fade away into the distance from that point. And that'll be clear when you see this plan. And the second major change is that through the good efforts of your board, as much as anything else, the building has gotten a lot softer. It's more residential in nature. Mr. Barletta made some suggestions which we've incorporated wholesale, and I think it'll be a more user-friendly building for the people in the neighborhood.
And I see that we were able to put the plans up. Mr. O'Neill, is there a way that we can have that available throughout the course of the meeting? Oh, here we go. Can you hear me, Mr. O'Neill?
Yes, we can have it as needed. I can have Kelly share it as needed.
Okay.
We can also.
That's perfect.
Okay.
I just want to make sure that I got it. And and I don't know about everybody else, but when I got it, it took everybody else and wiped them to the side. As long as you have them available, that if any member of the public or any member of the board wishes to refer to them, we can pop them up again. That would be great.
Can I ask a question? Just kind of going back to, it was like a public question of how would people how would they have known to come in knowing that the plans had changed? Do you know what I'm saying? So Chairman asked, did anybody come in to see the plans, but would the public have known that they had changed?
This same plan was presented to the planning board more than a month ago. I believe it was March 10th, and they approved that plan after 2 weeks of advertisement to the abutters, I would assume.
Okay, so they would have known from the planning that they had changed. So if they wanted a copy, they should have come in and got a copy. That's all I wanted to confirm.
That was one of the last live public hearings I've attended, and there were a number of people there, and I'm sure they're on the phone this evening,
okay,
who came to that meeting and looked at the plan presentation.
Yep, very good.
Okay. Before I open it up to the board, I have just a general question to our attorneys. And when I say our attorneys, I mean our attorneys on the federal case, and that would be Lenny, you and Greg. You know, can you please tell us, like, how did this get back here? You guys are our attorneys. Can you let us know, you know, what prompted this case to land back on our laps?
Mr. Chairman, I can field that. I think Attorney Bobrowski gave you a bit of the procedural steps that brought us back here, but I can try to provide a little bit of color for both you, the members of the board, and the members of the public that are watching right now. Let me back up a little bit and just talk a bit about the complaint. The complaint effectively alleges that the ZBA has discriminated against the facility, i.e. the prospective occupants of the facility because of their disabled status. And the allegation is essentially that it's in one of two ways, because of what's called a disparate treatment theory or a failure to provide a reasonable accommodation. Without getting too much into the legalese, there's a number of factors that play into the analysis of the disparate treatment theory. The one that we're focusing on right now that I think is the subject of tonight's meeting is the reasonable accommodation theory. And the simple answer to your question is that when this came before the board did not take up a reasonable accommodation that was initially provided by the plaintiff at that time. Throughout the litigation, we have discussed a number of the proposed amendments to the application that Attorney Bobrowski and Mr. Osgood have already gone over. And it's our view that as a matter of practicality and sensibility to the law, that it makes sense for the ZBA to take up this reasonable accommodation in the form of the modified special permit application that's now before you.
Okay, before, and I'm gonna want to get into that a little bit further, but I also just wanted to say, Ray, I got a message from Mr. O'Neill that there's some background noise with the kids and stuff on your end that's kind of causing some problems with our feed. I don't know if you can, I know we're all dealing with difficult stuff. I got a dog that was just barking too. But if you can just make sure that we can keep that down, because I think it's interrupting, from what I'm understanding from our IT guys, the feed. I just wanted to let you know that.
Okay, I'll check into it.
All right, now, Mr. Pagnini, I mean, look, we went to federal court. What happened? What's going on?
Why don't I field that, Greg?
You go ahead, Lenny. I'm sorry, did you say you wanted to field it?
Yeah. I'll tell you. We had to evaluate the case. We reviewed all the facts. We had conversations with the board. We had conversations, town council, and we determined that the best course was to try to resolve it. Everyone agreed to go to mediation. We went before a sitting magistrate judge. Her job was to mediate the case. That means she did evaluate the case. She spoke to both sides, and I can tell you that, and also she worked hard to try to get the plans in such shape that they would overcome any objections anyway. We also came out, all of us came out of that mediation with the understanding that the federal court did not feel that the town had a good case.
And
ultimately, she wouldn't decide it ultimately. It will be a jury in the end. But it is, when you have a mediation with a sitting federal judge, you do listen to them.
Oh, I know that, but without, and it's a delicate line, because your opposing counsel is listening to everything that we're saying, and the case, from what I understand, is still active. But can you I think it's important for the board, the town. I think it's important for everyone to know that in a case like this, if you were to not prevail, what could be the town's potential exposure? I want to know it.
Every time, there's a lawsuit, the lawyer who represents you, or the lawyer who represents the town, we do a lot of town work. Our job is to ascertain the facts as best as we can and give you the odds. Nobody knows what's going to happen in the end, because it's going to be, in this case, a jury that decides it. and also the odds of winning, and also what could happen if you lose. And in this case, if a jury accepted the plaintiff's arguments and the plaintiff's estimation of lost profits, whenever you're dealing with something that was not allowed to open, you don't have a track record. You know, if you shut down a business that has been open for 3 or 4 years and they say you shut them down illegally, you look back to see what they actually earned. Whenever you're dealing, as you do in this situation, with a new business, it's always speculative, right? Everybody opens a business planning on making money. But if, in this case, certainly if the jury accepted the plaintiff's numbers based on some facts, if they accepted it all, the city was looking at a multi-million-dollar judgment of the town against the town. Plus, in a civil rights case like this, the town would be ordered to pay the attorney's fees as well, which would be well into the 6 figures. So there was
6 figures meaning millions of dollars.
6 meaning hundreds of thousands. Million is 7.
What? And again, and I'll put it in a way that doesn't cause you any grief, because I'm going to put it in Attorney Brabowski's mouth. If Attorney Brabowski got what he wanted, and I'm not saying that he would, but if he got what he wanted, what's our exposure on this?
Multiple millions of dollars. I mean, that's the downside of losing. Plus, I mean, there's the potential of the issue. Like, one of the central issues of the case was that the ZBA determined that it would not even consider a reasonable accommodation, and that's a problematic decision at the time. And if it was found to be illegal, then there was personal exposure from members of the ZBA for doing that if it was found to be illegal. So there's also personal exposure.
I want to know, did the mediating judge have a problem with that decision of the ZBA?
Yes.
I don't want to ask any more questions. I'm going to open it up to the rest of the board. Anybody who has a question of the applicant or our attorney, but I have to caution you that there are some, limitations on what our attorney can share since the case is still technically ongoing. But I will open it up to the board to ask any questions of the applicant or counsel before I go to a public hearing. Anybody? Nobody. Okay. Mr. O'Neill, you ready to fire up the folks that want to weigh in on this?
I am. Just a reminder, if you're a caller, to hit the *9 prompt if you wish to speak. Right now, we have a caller, the last 4 digits of the number 2003.
Okay, and again, and I'm going to mention this one more time, just for anybody that may have just popped in after the beginning of the meeting, due to the technical limitations that we have here. And believe it or not, I would rather have this in an open meeting. I'm not a technological guy. This is very difficult for me. I have to have my kids helping me, show me how to scroll on a laptop. But I'm gonna have to limit everybody. Everyone who wants to speak is going to get a chance to speak. Everyone, but you're gonna get a chance to speak one time, and I'm gonna limit it to roughly 3 minutes. Mr. O'Neill, I've already told him to give me a heads up when that period is approaching. I'm not going to cut anybody off in mid-sentence. If there's something pertinent or it rolls over, I'm not going to be, a hard ass on it, but I'm going to keep it pretty tight. So having said that, why don't we go into the first person, and please introduce yourself by your name and your address.
Hi, my name is Catherine Bradley. I live on 6 Mystic Ave. I don't know if I'm in the butter or not. I assume I'm not, because I have never received any information about this through a town message, whatever. I'm just curious. So now we have it as this is going to go on septic, correct? This facility would be on septic. Is that correct?
Folks?
Correct.
Hello?
Yes, it's on septic.
Okay, so I'm just curious. Now, I've seen Ray Lepore in there pumping it out today. I've seen Lepore in there pumping that area out quite a few times early in the morning, usually between 5:45 and 6 a.m. on my way home from work. So my question is why is Ray Lepore in there pumping out a area that isn't even developed yet? Is there issues? Are there problems with the wetlands and such going into this area? Like, my concern is the whole septic thing, because I'm also on septic. Would they be going to, sewerage, etc.? I mean, I'm just curious.
Can I speak on that first, Mr. Chairman? First of all, 5:45 in the morning, my trucks don't leave until a minimum of 8:30 to 9 in the morning. Second of all, I haven't been on Mr. Nealon's property at all. Well, could you tell me what the address they're on?
Excuse me?
Can you tell me what address they're on? The address?
They're right in front of that, between the train station and Citgo. Is that not the property? I must have that confused.
I'm not on 362, no, and I'm not on the Shell station, and I'm not at Eli's. The only one possibly, would be Uptown Deli, and I'm not there that early in the morning. My son drives.
No, you're not there. You're right across the street from Uptown Deli, which is between Citgo and the train station. I'm just asking. Don't lie. I mean.
No, I'm sorry, but my trucks do not leave until 8:30, 9 o'clock in the morning.
All right. Yeah, you know what? This is going. Hold on, ma'am. This is going in an odd direction. Are you asking whether Mr. Lepore is working on the property in question?
I am asking why his vehicles are on the property at that time in the morning. And today, when I went by there, they were there again today. I'm just wondering why they're there so early. If there's undeveloped property there, what is the need about this property?
Okay, he's gonna check into it. He's gonna ask. But your question is whether his vehicles were on the actual property at 362 Middlesex.
I know that they were. That isn't my question. My question is, why do they see the need to service that area if it's undeveloped? So when it gets developed, how often are they going to be there?
Okay, all right, Ray, this I'll take this as a point of personal privilege, because you're being, I think you're being accused of being on. It's not a question. You're actually being accused of being on the property. So why don't you answer that?
No. I just want to know. I know it is. I'm not trying.
Well, hold on, ma'am. You said you know for a fact that Mr. Lepore's vehicles were there on that property today. I'm giving the man a chance to respond to you. Let the man respond.
100%. Yes.
I can, Mr. Chairman, I just checked with my son, Christopher, and he was not on that property at all today or ever. He said a service drain and pump that's doing that property. Zani. That's not our trucks.
All right.
The Lepore truck is not your truck, correct?
I own Lepore trucks. You're absolutely correct. But my truck is not there. I don't know where you're coming up with this. My driver and my son that operates the business, I do not, is right here. And in fact, I just checked with him, and he said if you want, he'll pull the slips tomorrow down the town hall and give you exactly who pumped it.
Okay, and that's been over the 3 minutes. So we're gonna go to the next individual, Mr. O'Neill.
We do not have one, Mr. Chair.
There's no one that wants to be heard on this? I find that hard to believe.
We do have one now. Last 4 digits of the number are 3881.
Okay, welcome. Can you give your name and address for the record, please?
Sure. Excuse me. Sure. My name's Kevin Brander. I live at 5 Catherine Ave. And it's pretty amazing just hearing this level of discussion, and it just amounts to what seems like a lot of bullying the board into taking a certain position. And I really think that this would set up a setting that would lead to disparate treatment. think if we revisit the reasons that the special permit was denied, it was because it wasn't in harmony with the neighborhood. And I think Mr. Syracuse even went so far as to say it was the size and the height of the building. And he was very clear that it wasn't about the use. And those things have only changed minimally in this proposal right here. And if you look at the guidance for reasonable accommodation, it's not something that the board has to do without any guidance. There's actually guidance on this. And the reasonable accommodations that are included in the guidance talk about things like putting grab bars on tenants' bathrooms and allowing assistance animals. So, you know, we're talking about something that's on a different plane than just waiving use requirements as far as typical requests for reasonable accommodation. And I'm hoping that you received a letter that I wrote that indicates some case law on this matter, which indicates...
Brando, I don't want to take up your time, but just to let you know, we did receive your letter. I read it, and it's been submitted as a part of the record. So go ahead. Okay. So the only thing I'd just like to highlight in closing is that there are cases involved where facilities were proposed to be sited where towns worked with the proponents to find more suitable locations that were consistent with town's master planning. And we have such a case right now. The town meeting took an action in 2017 to open up this type of use in industrial areas. And Mr. Nealon actually owns property that could be affected and could actually create a pathway for a detox facility on land that he owns on Ballardville Street. And if you went to LoopNet, which is the sort of the clearinghouse for commercial space, yeah, even today, as we speak, he's marketing 196 Ballardvale Street as available for uses. So I think the town did create a reasonable accommodation by making that zoning change and showing him a pathway where he could site such a facility and having it much more consistent with the master plan for the town. I guess that's all I had to say. Thank you, Mr. Brander. And again, your letter was received. I believe it was forwarded to the entire board and it was made part of the record. I appreciate it. Thank you. Anybody else next? Mr. O'Neill.
Mr. Chair, we don't have anyone at this moment.
There's no one?
We just got another one.
Okay.
Caller 6869.
Hi, can you?
Hello.
Hi, can you give us your name and address, please?
Sure. Patricia Xavier, 40 Oakdale Road.
Hi, Patricia.
I just had a quick question. I believe at the last zoning board of appeals, well, original one of the concerns and one of the reasons that it might not have been passed, my understanding was there was concern with the size of the building. And from my understanding of the plans, the current building is actually a little bit taller. So I'm just wondering what we're considering here. If one of the concerns that were brought up before was the size of the building and the new proposed building is taller. So that's my first kind of question for clarification. And then I think the understanding that I heard tonight, the attorney for the applicant used the word similar to this technology. I'm not sure if I heard it exactly, but something along the lines of no longer having a vested right to apply for a special permit. So I just want some clarification of, is this an acceptable use? And if there is no longer vested right, why are we considering it? So if I could just have clarification on that, I would appreciate it.
Thank you, ma'am. And I would suggest that maybe Attorney Bobrowski, maybe both of you can address those questions. There were two questions. One sounded more like a logistical property area question, and one sounded more like a legal question. If you could answer them, that would be helpful.
Dan,
sure.
before
as to the building height, Mr. Chairman, I believe we comply with the limitation in the district. The building did get a little bit higher, but it was to accommodate the suggestions of Mr. Barletta and others that the building take on a more residential appearance. So we're not in excess of the height. Ben, if you would correct me if I'm wrong.
No, you're not. No, you're correct, Mark.
So that's the reason the building got a little taller. It actually makes the building look more residential in nature. And then the second aspect of the questioner's remarks has to do with the December 17 rezoning in the GB district to eliminate, I think it was hospitals and clinics was the line item, and to prohibit it. We filed a definitive plan before that vote of town meeting, which froze our rights to continue to apply the right to apply for the special permit that was ultimately denied by the board. In order to continue under that plan, we had to show, thank you.
And just, by the way, we're showing the elevation of the building for anyone who cares to look.
And you're looking at this from the Middlesex, so the closest neighbors are to the rear of the building. With regard to the subdivision approval, if you'll recall, that was a particularly ugly plan. It had a giant cul-de-sac in front of it because the lot was without the requisite frontage. I believe it has 116 feet of frontage in a district that requires 125. So we literally had to create more frontage in order to be eligible for that special permit. The plan, everyone agreed, was harsh. And so in asking for the reasonable accommodation, we went to this plan. This plan does not create any frontage. We have deficient frontage here. That's why we're not eligible for a special permit.
Okay, gotcha. I appreciate that. And Mr. O'Neill, I appreciate you having those plans available for us to use as needed. Okay, why don't we take our next question in the queue, Mr. O'Neill?
It's empty, Mr. Chair.
All right, well, let's wait a second because I don't want to close the public hearing. I'm going to hold off.
We do have a caller, two callers now. First, I'm going to unmute 4808.
Okay, hello. Can you please give us your name and your address, please?
Hi, yes, Jacqueline Ribeiro, 2 Judith Road. I just had a question. In the original Zoning Board of Appeals meeting, Mr. Lepore and Mr. Siracusa, their reason for denial was the height of the building. And I believe Mr. Siracusa even asked if they would consider, maybe a one-story building, which they adamantly opposed. So I just wanted to maybe have you clarify, are they asking for an accommodation on the height, or are they asking for an accommodation on the use? Or are they just asking that everything that the bylaws are for be excused so they can put this in here? Can someone clarify that?
You know what, I'm gonna direct that question, ma'am. I'm gonna direct it to the attorney for the applicant, because I mean he's in the best position to tell you what he's asking for. But I do understand that there's a difference between the actual physical layout of the building and the accommodation. And I think it's important that we delineate what the differences are.
Well, right, because you have two members of your Zoning Board of Appeals who had a legitimate reason to deny this. And now you're bringing it back and don't change the height, which was the reason why they denied it. So what are you expecting out of this? Why would they change their mind on the height now?
Hold on. No one, we haven't voted yet, so no one knows whether anybody changed their mind.
They're bringing it back, obviously, hoping that they change their vote.
Hold on. You asked the question.
Yes.
I'm posing, first of all, you made an assumption that hasn't happened yet, but I'll set that aside. But you've asked.
Well, they would come back hoping that they would win, so that would mean they would have to change their mind. That's all I'm saying.
So you're putting words in both Mr. Syracuse's mouth and Mr. Lepore's mouth. But I'm going to set that aside. You asked the question, and that's what we're here for. And I'm going to direct it to the attorney for the applicant. Attorney Bobrowski,
thank you.
Can you answer the questions, please? Thank you.
The specific accommodations that we seek, Mr. Chairman, are for the frontage deficiency and for the use, which is prohibited in the district now. We do not need an accommodation as to height, as Mr. Osgood just confirmed for me. And my recollection of the discussions that we had at the end of the special permit process were that the gentleman expressed some concern about the massing of the building. We have addressed that issue by tilting the building, if you will, on an angle so that it's not, again, parallel to the buildings that are behind us, and our neighbors to the rear won't see the entire rear wall of the building.
All right, so to clarify for the individual's question, what is the exact nature of the accommodation you're seeking?
Frontage and use.
Thank you. Okay, next question, Mr. O'Neill.
We have caller 0179. I'm going to unmute.
Hi, can you please give us your name and your address, please?
Sure. My name is Kelly Richards. I'm at 31 Shady Lane Drive.
Hi, Kelly. What's your question or comment?
I have a comment, a couple comments and a couple questions. You know, this has been a long and frustrating process, mainly because it has quite shockingly been an unjust process. And as residents, oftentimes we felt like our local government was literally working against us. A just government is to represent and protect its citizens' natural rights and property. But now, if I'm understanding some of the information that's been presented, it's pretty obvious that our Board of Appeals members have been under an incredible amount of pressure. So I'd like to clarify. I have a couple questions to make sure I'm understanding things correctly. So what will happen if this is voted down today, if they get a no vote? Does that mean that it will go on to court? The town of Wilmington will be sued. And well, I'll start with that question.
No,
because
Kelly, you got 3 minutes and you've used one. So why don't you ask all your questions?
Okay. So I want to know if the town of Wilmington will be sued. It also, if I heard correctly, it seems that members of the Board of Appeals will personally be sued. If that's the case, we're really going to have a problem finding people who want to serve on boards, because nobody wants to be personally sued. And so I'm also wondering if the town of Wilmington is going to represent their board members who are volunteering. And lastly, I'll state that this is a 24-hour facility. It doesn't meet zoning. Mr. Nealon, the petitioner, has had exceptionally special treatment, more special treatment than anybody else in town. It does not fit harmoniously in with the neighborhood. This vote would be precedent setting not only for Wilmington, but the entire country. And they should receive a no vote.
Okay, Kelly, I take that last one as a comment, and it's well taken. But I think the questions, as I can, and I'm going to direct they're going to direct two of the questions to Attorney Bobrowski, because you're the man holding the cards. If we vote this down, what would be your next step, and what would be the exposure to individual members of the board? And then I'm going to throw the question back to our attorneys and say, if there is exposure to individual members of the board, who would represent them and pay for the representation? Why don't we go to Attorney Bobrowski first?
Thank you, Mr. Chairman. First, we've already sued the town, so this is not something that we're waiting to do. We've done it. We did it a year ago, around a year ago. We're in federal district court. Judge Saylor has ordered a remand. He's waiting patiently to see what happens. If this does not result in a favorable determination, we'll resume the case in federal district court. As to whether the individual members would be named outside their representative capacity, I haven't thought about it. I'll make that decision when the time comes. I would note for the record that they were not named in anything but their representative capacities in the original complaint I filed in Superior Court, which was removed to federal district court.
Okay, and then I would ask, I guess it would be Attorney Keston, if any individual member of the board were to be brought into this in their individual capacity, who would represent them and pay for that representation?
The town's insurer. The town has insurance for all of its public officials, as do all towns below a certain size.
Well, hold on. I mean, I know enough to know, though, that there are some exceptions to, you know, you get municipal immunity to a certain degree. You're also covered by the town to a certain degree. But if there are some actions that a member could take as a board member or as a municipal employee that, you know, are either reckless, willful, wanton, discriminatory, that you're on your own. Is that something that could happen in this case?
Here's the, I don't think so. Well, here's the situation. Right now, the way it works is a town gets sued in a case like this. This happens in every town. It happens to multiple boards for various things. The towns, in this case, it's Maya, which is in most towns. Maya has, they look at the insurance contract and they decide whether it's something that's covered. The only thing that typically, and I don't make those decisions, isn't covered is if the allegation is that you did something outside the scope of your employment, something outside the scope of being a zoning member. In this case, right now, the way the suit has been that Mr. Bobrowski has filed on behalf of his client. He has sued the individuals. The insurance company is paying for the defense. If he sues them in their individual capacity, then they still, typically they would still be defended. But if the jury found that they acted in a willful, wanton, and reckless manner, then the insurance company would likely say, we're not paying that.
What about a discriminatory matter?
It has to be willful and wanton. Even if you're found liable for discrimination, that's still covered.
So the insurance company would defend the members even in their individual capacities under a reservation of rights, but if a judgment were to enter, they may be on their own to pay it.
If the judgment finds, if they're awarded against what I call punitive damages. So if the plaintiff wins this case, the plaintiff is entitled to what's known as compensatory damage. That is, in this case, would be lost profits. They'll be entitled to their attorney's fees that they've expended. However, if the jury finds that one or more members who are sued individually acted in a willful, wanton, and reckless manner, then the jury can't award a amount of money to punish that member for doing so. And typically, that is never covered by insurance. And that's when it's your personal exposure, and that nobody knows that until right now. The lawsuit does not provide for that.
Is the lawsuit seeking punitive damages at this point?
Not at this point, right, Mr. Bobrowski?
Correct.
Yeah, okay. The lawsuit is filed right now not going to affect anybody's personal finances the way it was filed. But that can always change.
Understood. Thank you. I think that answers the questions that were posed. Mr. O'Neill, is there anybody else next in queue?
We do not have anyone at this moment.
I'm going to wait because it seems like there might be a lag.
And I'm going to Georgia to get another haircut.
Anybody
yet?
Vegas. Anybody yet, Mr. O'Neill?
No one yet.
Okay, I'm going to wait another few seconds here before I call it out. All right, we've waited about 20 seconds. I'll wait another 10. Going once, going twice. Nobody yet. There we go. It's like when we're in a public meeting and nobody's standing at the microphone, and then we're about to close it and somebody runs up. Have at it. Can you please give us your name and your address, please, for the record?
This is George David, 40 Oakdale Road.
Hi, how are you? What's your question or comment?
I just have a quick question. So, Mr. Bobrowski brought up that they're requesting for the plan to be approved for frontage in the accommodation use because the use is no longer valid. I guess the question to the board is, when's the last time that a resident has gone before this board for the same exact case and it's gotten approved? That is, general comment or question. I mean, how often does that actually happen? And I'll leave it at that.
Okay, who I'm not clear who I should address the question to, caller. Do you want me to address it to a certain person?
I guess I go for you. You're the chairman. So as a chairman, how often do residents of this town get their plans approved going for frontage or accommodation or different accommodation in their use of the property?
I gotta tell you, this is the first time I've ever run across a case regarding any type of accommodation. So I can't speak historically on behalf of myself. I mean, I can defer. Here's where I might call in our town council. Jonathan, you with us?
I'm here.
Okay. Can you answer the gentleman's question based? I mean, how many towns does your firm represent?
As primary counsel, about 130, and then as special counsel, another 100.
All right. How long you been slugging it out in this business?
Since 1996.
Okay. Can you answer the gentleman's question? Are you aware of any similar situation to this?
You know, obviously every case is unique, but I'm certainly familiar with other cases where land use applicants have requested accommodations, and I'm familiar with other instances where it's gone to court and where it's been resolved, where town council in Wenham, before we became town council in Wenham, and my firm had no involvement in the case, but I believe Mr. Bobrowski did, and he may be able to speak to what happened in that case. In fact, I think he may have represented the town in that case. There was another similar situation where an accommodation was denied at first. It was ultimately granted after a settlement following mediation in the federal court litigation. That's just one that pops to mind, but certainly this does happen from time to time. Obviously, one time is more than any town wants to see, but it typically doesn't happen multiple times in one community.
Okay, thank you. I think that probably gives the answer that the individual is looking for, or at least answers the question that he was posing. Anybody else, Mr. O'Neill, in the queue?
We have caller 5614.
Hi, can you please give us your name and your address, please?
Yes, Joe Ribeiro, 2 Judith Road.
Hi, Joe.
I just have a statement to the board, just to reiterate that, you know, how you guys voted the last time. We defeated it with the 2 votes, and with the two gentlemen that voted against it. I mean, I'm looking at the plan, and I don't see any changes. I mean, it's not harmonious to the neighborhood, and I think the only thing, would change anything is the fear of them being sued. And it seems like it just doesn't seem right to me. It's like, are they going to be nervous about being sued? Is that why they're going to change their mind on the vote? Because the plan hasn't changed. So I just hope the town, backs these 2 gentlemen, how they really believe and, how they voted. Being threatened to be sued should not be a factor in this case. So that's just my thing. I applaud the 2 gentlemen that voted with us, and I hope they stay with us. And, because I think it's a threat, and I think they're going to look, we're going to win in the long run. I think if they hang in there, I think we'll be okay. Thank you.
Joe, okay, you still got some time. Do you have anything else? Or what I'm inclined to do, and I'm not going to take my comments away from your time. What I'm inclined to do, I'm going to direct your question to the 2 members that you referenced. I think that's only fair to them. But before I do that, do you have any other questions before we go to them and say goodnight to you?
No, that's my main thing. It seems to me that the plan hasn't changed. They weren't in favor of the 2-story building, and in fact, it's even gotten higher. So I mean, that's even more of a reason not to change their minds, unless they're are nervous about being sued on their own, which I don't blame them. But that shouldn't be a factor in this case.
Okay, thanks.
Thank you.
Tom and Ray, I mean, obviously you guys, you haven't voted yet, and I'm not going to put words in your mouth, but, I guess the particular question was regard to the changes in the physical layout. I mean, I read that out of it, that they were Joe was talking about the height and everything else. Do you want to address how maybe the changes affect how you feel I'm not saying you feel differently, but do the changes that he articulated have any impact on you? Either one. And you don't have to answer it, but I mean, he kind of called you out.
Okay,
okay, go ahead, Tom.
So, we looked at that building for the second time. I was at that mediation meeting in the federal court. And it was clear where this was going, that the actual building that we had turned down was not harmonious to the neighborhood, and it clearly was not. And so they were given an option to make the building more harmonious. Now, it is higher, but it's just a pitch height. And the actual size of the building has, in fact, the actual workable space of the building has, in fact, been reduced in size. And the building has been moved forward away from the residents. And that's all I have a comment on that.
Okay, Ray, do you want to address Joe's comments at all?
Well, I have a few, a few questions. Well, one question first is the accommodation, one of them obviously is the frontage, but the second one was the use, changing the use from the general bylaw. I guess I'd like to ask Attorney Silverstein if, in fact, is that the legal rights that we have to do, actually change the zoning instead of a town meeting vote, that the 5-member board's changing the zoning, which in fact there is no grandfather rights to this property as far as the zoning. And the second question would be that if the use is turned down, is because of the people being discriminated against, supposedly, that's what it's about as far as the legal case. Would that be the draw of the discrimination? In other words, because we turned down the use, that's discriminating the parties that what this facility is supposed to be used for.
So I don't want to step on the toes of Lenny or Greg, and they may want to jump in since they're defending the town, and the board in the litigation. But I'll take a crack at this, Ray. So the use at the time that the applicant froze zoning through submission of a definitive subdivision plan or preliminary subdivision plan, which was followed with a definitive subdivision plan, and that plan was endorsed by the planning board. So they froze zoning at a time when the use was permitted by special permit from the ZBA. And that's the special permit they applied for. Now, so at the time, they didn't need to, in the original application for the special permit, they didn't need any accommodations from zoning because the use was allowed with a special permit, which they applied for, and they had created adequate frontage with this cul-de-sac. During the course of the mediation and I think deliberations last time around before the board, I think many people on the board felt that it was unfortunate that the applicant needed to go through all this process to create frontage, put in this cul-de-sac road, and push the building way back closer to the neighbors. I think the applicant, in order to address and mitigate some of those concerns, and as a result of the mediation, said, well, look, we can A, improve the appearance of the building itself based on comments from members of the board. B, we can move it closer to the road and not have this big cul-de-sac road whose only purpose is really to create frontage. But the only way to do that is by requesting an accommodation from the ZBA. So they could go back and they could, in the litigation, they would say, okay, we'll go back to the original proposal, which doesn't need an accommodation from use or from frontage. But I think the wide view among members of the ZBA was that plan is worse than this plan. So if the ZBA wants to have the better plan that's puts the building further from the neighbors, the way to do that would be by granting the accommodation. And yeah, I don't want to speak from Mr. Bobrowski, but on the issue of frontage, the question is whether it's fundamentally undermining the purpose of zoning, where they could create the frontage, but only through a plan that the board doesn't like as much. And does it make more sense for the board to grant an accommodation on frontage? And again, on use, they could stick with their original plan and get a special permit pursuant to the original zoning. But again, this proposal came about as a result of the mediation. So does that answer your question?
Yeah, and I'll just like to follow up with the, with the legal part of it. I mean, listen to the advice of the three attorneys sitting in, and also reading some of the correspondence that was sent from the other party. I'll be honest with you. If a judge was to look at me and ask me the question, do I feel intimidated as far as being sued personally, between my pockets and the other party's pockets? Absolutely 100%. This thing is worn on me. I can't sleep at night, to be honest with you. It's taken a big toll on me. I'm always around town, as you know, and I'll be honest with you. I have to tell it the way it is. And absolutely, I didn't get the right answer. The feeling I'm getting from the attorneys are, yes, I'm subject to a personal lawsuit. And anybody that sits on a board free of time, and that, like the gentleman said, to give time to a town board and be put in a position where, in fact, you could lose everything that you worked for in your life. Nobody wants to be in that position. And unfortunately, I'm here tonight in that position. That's the feeling I have. I'd just like to leave that with the gentleman that asked me that question. I just want him to know where my feelings are really coming from.
Fair enough, Ray. I understand your position. Mr. O'Neill, do we have anybody else?
We do. We have 4 in the queue right now. The first one up, 9358.
Okay. Hello, can you please give us your name and your address, please?
Ethan Sawyer, 58 Lawrence Street.
Okay, Mr. Sawyer, what's your question or your comments?
So, I guess, after listening to everything so far, it seems pretty clear that, this really is a decision that comes down to risk of financial loss to the town, the upside and the downside of each potential outcome. And that's why everyone's hearing this again today. It really comes down to, I guess, hazards of litigation, what the cost could potentially be. And I know that it's before this board for a vote, but I'm just wondering, I know sounds like it was at the advice of the town council, the insurance company, their representatives, but I didn't know if there was anyone else in the town that weighs in on the decision and what is ultimately, what risks are worth or not worth taking when it comes to this whole process. Because it seems like a decision's been made that, that the risk is not worth it. And so I'm just wondering, besides this board, I think the town manager factors in on this stuff. I don't know if the board of selectmen do, but I'm kind of curious who else is involved in the decision-making process to get us here today.
Thank you, Mr. Sawyer. I will say this, and I'm gonna kick this question to our town council, Mr. Silverstein. But from what I'm aware of, the entire town, as far as the town administration, has been involved in this. That includes the manager, the planning board, the board of selectmen, and now the zoning board of appeals. So I think that this is not something that is just being directed by the zoning board of appeals. This decision is being made by the zoning board of appeals. But believe me, this particular lawsuit has been vetted by everyone in town, including the Board of Selectmen. Now, I don't know what Mr. Silverstein is empowered to say, but I will ask him if he can make a comment, Mr. Sawyer, on your question. Jonathan?
Sure. Thank you, Mr. Chair. So as you know, the planning board did vote on this plan through its own accommodation request that Mr. Bobrowski submitted. The planning board did approve that after a public hearing. The Board of Selectmen and town manager control litigation. Obviously, when the town is sued, it might be a particular decision of a particular board that's prompting the lawsuit, but if there's a judgment against the town, or if there's a claim that implicates the town's insurance, then only the chief executive body and the chief administrative officer of the town, which are the Board of Selectmen and the town manager, respectively, they have to obviously be aware of and deeply involved in the defense of that litigation. So I can tell you that certainly the town manager is aware of the litigation. A member of the Board of Selectmen was present for the mediation. The Board of Selectmen has met and discussed in executive session the litigation. I cannot tell you what was discussed in the executive sessions, of course, but I can certainly tell you, and it's public record, there have been agendas where the executive session to discuss this litigation has been included. So I can share that much with you.
Let me ask you, Jonathan, I understand that there's pending litigation, federal court litigation on this particular case. At some point, will the involvement of any of the boards or individuals that you enunciated be made public?
Well, I mean, certain information might become public. As a general rule, executive session minutes that are comprised of discussions that are protected by the attorney-client privilege, and this is right in the statute, do not become public records. But ultimately, of course, it's the board's decision what it chooses to release.
Understood. I get it. Okay, Mr. O'Neill, do we have anybody else in the queue?
We do. This is showing up as call-in user 2.
Hi, caller. Can you please give us your name and your address, please?
Rob Fasulo, 28 Marjorie Road.
All right, Mr. Fasulo, what's your question or your comment?
I got a question for Mr. Silverstein, and possibly I got a question for you, Mr. Chairman. Attorney Silverstein, has reasonable accommodation ever been used for new construction? And I want to stress new construction anywhere in the country. And if it has been, can you give me a citation that I can look for? And then the question for you, Mr. Chairman, is where were the rules that you guys are operating this meeting created? Who's dictating the votes? How many votes do you need? Where is that spelled out in legalese per se, so that we know that things are being actually done right?
Well, I guess, Mr. Fasulo, I'm going to take your question to me as a two-part question. The rules that we operate are the same for every meeting, but this particular meeting, obviously, we're in a whole new world here. So, and there are some rules, from what I understand, that have been promulgated for these type of virtual meetings. So, Jonathan, first of all, can you tell us what rules we're operating under, both for entertaining the reasonable accommodation and also under the virtual meeting guidelines, what we're dealing with? Because I'm not even entirely clear on that. I know the instructions I got from the governor via the town, but can you kind of, let us know what we're running under here?
Sure. So generally with respect to reasonable accommodations, and as the board knows, I provided some confidential guidance on that a year or so ago. But generally speaking, what the Department of Justice and Housing and Urban Development guidance says is that a board is supposed to use its normal procedures when it's dealing with a request for an accommodation. So that basically mean, that's why this was, the ADA doesn't require 2 weeks publication of notice, for instance. It doesn't require a public hearing, but the board has decided to utilize its normal public hearing notice and publication procedures that it would use for any of the business it conducts for this accommodation request. So basically what the guidance says is use your normal procedures, and that's what you're doing. With respect to the virtual public hearing, this is all new ground for the board. It's new ground for boards across the state. There is guidance in the form of the governor's executive order that suspended certain provisions of the open meeting law. And essentially what it requires is that where there's a public hearing, there needs to be the ability for members of the public to have real-time ability to follow the proceedings, and during public comment portions of the proceedings to be able to make public comment. And obviously that's what the board's been doing for for this hearing this evening. So that's what those procedures are.
I can anticipate a question that folks at home might have as to, no one knows how long we're going to be going through this. But why are we doing this now? Why couldn't we have waited, to have a full open meeting where people can gather and shout out and whatever they hadn't done in the past? Is that, why are we doing this now? Jonathan, is there, any particular both legal or practical reason why we're having this meeting now?
Well, again, I'm not counsel of record in the litigation. I'm generally aware that there.
Then hold on. Then you can say what you want, Attorney Keston or Attorney Pagnini. If you want to chime in, do so. I would like to know: is there any particular reason why? Obviously, we need to do the town's business. Other meetings are being held this way in other towns and in the town of Wilmington. We need to move on. But if there's a particular reason why we're having this meeting now tonight, I would like to know it, and I think that maybe the people at home would like to know it too. So, Jonathan, why don't I go to you first, and if
Sure.
our insurance counsel wants to chime in, go ahead.
Yeah. So, as I said, I'm not counsel of record in the litigation, but as I understand it, there was as part of the discussions after the mediation, there was a commitment between counsel and made to the court to act within a certain period of time. I believe Mr. Bobrowski said it was by April 1st. That comports with my memory. Obviously, after the planning board held its hearing, as was mentioned, the state of emergency, the emergency orders prohibiting gatherings of more than 10 people, prevented the board from holding the meeting the public hearing as originally noticed. There was a discussion at that time, I can tell you, with Mr. Bobrowski, where he was really hoping that the meeting could proceed as originally scheduled in a virtual context, because the governor had already issued his executive order that would allow for it. The town didn't feel like it was set up to do that yet and asked for more time. And after some discussion, Mr. Bobrowski, somewhat reluctantly, but did agree to postpone the hearing to tonight. I don't think he would have agreed to, and he can speak for himself, but based on my conversations with him at the time, he wasn't willing to agree to put this off indefinitely. And then it would have been a matter of simply proceeding with the litigation. I can tell you also, I would have a concern that, as you mentioned, the town is proceeding with its regular business. Most towns are, because who knows how long this will all last, and when in-person meetings will be possible again. And if this were the only application, the request for an accommodation in the context of a discrimination complaint, if this were the only case that the board refused to proceed with, I think that would be problematic. But I'll let.
I have a question for Attorney Keston. Attorney Keston, are there any type of legal or judicial considerations that are prompting us to have this meeting now rather than waiting to go down to whenever we open up?
There's a simple issue of equal treatment. You can't treat people unequally because of something. The town's business is going on. You can't single something out. Secondly, we had agreements. There was a negotiation of this case for quite a while, and the plaintiff, Mr. Bobrowski's client, they were reluctant to wait till April. I mean, they wanted this thing to move. All of us had to explain to them there's a process. So it would be impossible to explain to a court. It would be bad if we said, if the town of Wilmington says we're going to do all of our other business, but not this one.
Let me add to that for a second, because with this now in suit, we have to proceed pursuant to court-ordered deadlines in the case. We effectively got what's called a stay of deadlines in order to conduct this hearing. But that's with the expectation from the court that it would only go on for so long, and we'll have to report back. So the court is sort of looking to us at some point to report to them if the case is going to proceed forward. So as a matter of sort of economic jurisprudence, we have to continue business as usual as best we can under the circumstances in order to go back to the case, proceed with the case if we have to.
Okay, I understand. Okay, I think there may have been one other question from Mr. Fasulo for Jonathan. I can't remember it though. But he did have a few, and I thought I tried to answer them, but I think there may have been another one. I don't know for Jonathan.
I think he was asking for case citations for other cases that involve new construction. I'm certain there are cases out there. But I don't have a case at my fingertips. What I will say is there's nothing in the discussions in the case law that I'm familiar with. And again, I'm not defending this case. I'm not counsel of record in the case who's going to be defending the board from these claims. So, I think you may want to hear from Lenny or Greg.
No, all right, then.
But there's nothing I'm familiar with in the standard for what constitutes discrimination under the ADA that distinguishes between new construction or remodeling an existing building.
Lenny or Greg, do you have any input into answering the question? Do you have
my quick response to that would be I'm not aware of any case law that makes a distinction, a material distinction between new or old construction.
Okay. All right. Let's see. It's okay. Mr. Fasulo has his hand up again. Do you want to allow him to speak? You know what? I was keeping time, and it looked like he only used like 2 minutes, so he gets 1 more minute, Mr. O'Neill. I want to be fair. I want to be fair to everybody. So if he has another question, he's got another minute.
I only wanted to clarify that question that I had asked, and you guys answered it, I believe, as good as you could. So I appreciate it. Thank you.
All right. Good night, sir. Mr. O'Neill, do we have anybody else that's lined up in the queue?
We do. 7441.
Hi. Can you please give us your name and your address, please?
Hi, Susan Rogers. Can you hear me?
Hi, Miss Rogers. We can hear you.
Hi, Susan Rogers, 10 Shady Lane Drive.
Hi. Can you give us your question or your comment?
Yeah, I have one of each. And I think it was partially addressed. I would like to say that there's been a cloud over this entire process, and I'm one of the abutters. With what urgency are we holding this meeting in the manner that we are? The state's been closed down. schools are shut down, and Governor Baker ordered all non-essential businesses and government services. So what's the emergency here that the ZBOA feels the need to hold a meeting that's largely inaccessible to most townspeople? Unless you have access to technology to even view it and to participate, that's an entirely different skill set, which doesn't, take into consideration everybody in the town. So I find it an exceedingly poor taste to even be holding this meeting. Just because you can doesn't mean you should. My question is of the legitimacy of the claim of discrimination. We have no physical structure. We have no actual patients. So I'm trying to understand how the ADA relates to discriminatory behavior in the suit. Rather, what I'm hearing this evening is a twisting of two fine gentlemen, upstanding members of the community, Mr. Siracusa and Mr. Lepore, being called into question about their original votes, which were based on the septic system, on the size of the building, on the accessibility to emergency vehicles, the draw on town services. Those were the things that they considered when they voted no in the first place. Now I'm hearing words like scare tactics, and it seems to me these two gentlemen, for fear of their own future finances, if there were to be a personal lawsuit, are voting under duress. Why and how is this even allowed to be happening without townspeople being present to say anything? I think this is an attempt of sort of to scare people into something that may never even happen, and it's about calling somebody's bluff. I'm very disappointed. I'm disappointed in the ZBOA even holding this meeting. Thank you.
Thank you, ma'am. I guess what I'm going to do is the first question you asked, I think, was, at large degree answered by Attorney Silverstein as to why we're having this virtual meeting. I guess I'll kick it to him briefly if he wants to recap it again, if there's still a question amongst anyone as to why we're doing this now and in this manner. But then I'm going to go to Lenny and I'm going to ask Attorney Keston if he can talk about the discrimination issue. I'm not going to go to opposing counsel and ask that. I'm going to ask our counsel, and you can say that. But I will say something. No one's taken a vote here tonight. Everyone has their own mind. We all deal with pressures. I think I can speak personally. I've dealt with a lot of pressures on this case for a number of years now. I've been threatened. A lot of stuff has been happening to me. So we all have to at some point stand up and speak our mind, whichever way the chips fall. And Tom is a good man and Ray is a good man. And I think that they can speak for themselves, and they will. So I'll set that aside for later. But Jonathan, if you can briefly talk about again why we're having this virtual meeting briefly, and then Lenny, if you can address her question regarding the discrimination portion, I think that would be helpful.
Sure. Again, I think Mr. Keston summarized. There were commitments made to the court in the federal litigation. In which he and Greg are defending the town. And there was a short continuance that was agreed to by the other party. But that was for the purpose of the town sort of being able to put together its procedures and technology to get it in place to be able to hold virtual meetings. The town is now in that position. It held a public hearing on the 4th of July event right before this one. I think you might have another hearing after this.
Are these virtual, Jonathan, let's just cut to the chase. Are these virtual meetings for towns, are they commonplace now at this point, after a few?
I've done probably 20 of them or more since in the past month.
So like 20 of them.
And that's me personally. I'm one of 45 lawyers in the firm. So, there are nights where I had one at 6 o'clock for Tisbury right before this one. Yeah, sometimes I have 2 or 3 a night.
Okay, all right. So they're becoming commonplace, at least more so now.
Yeah, and again, it's because I think towns are for a while, and this is true of Wilmington, towns were sort of reticent to do it for the first couple weeks of the state of emergency. I think people are sort of starting to come to the realization that this may not end on May 4th. You know, the governor just canceled school for the year, and no one knows when it's going to be possible to have an in-person meeting with scores of people packing a single room. And so I think many boards are coming to the realization they can't put off their business forever, because A, these matters need to be dealt with, and B, if you keep putting everything off, it piles up and it's going to be unmanageable.
Okay.
You know, when it finally does happen.
Fair enough. Now, Lenny, can you address the second part of the caller's question?
Sure. Just on the first part, let me just add also, what John says is so true. It affects everything, certainly in our world. It affects town government. It affects litigation. You know, we have recently had a meeting with the clerk of the federal court to ask when is the next jury trial going to happen. And right now, there's a good chance there will not be a jury trial in this Commonwealth until next year.
Yeah, I know that.
So you can't, so you can't keep putting stuff off if we had a finite end. So yes, this is happening around the state. Everybody's gone to virtual meetings, in large part. Yeah, if everyone knew it's going to end next week, then sure, you could say we could put it off for a week, but you don't know it's going to end. As to the discrimination, I take that question as to the how the case may end up. When we try a lot of cases. It's what we do, and it's up to a jury, and a jury has to decide somebody's state of mind, which is a very hard thing to decide. There's never anybody that says, yes, I did it. That doesn't happen. So the jury has to decide what was the motivating factor. And for us, as your lawyers, we have to look at it and say, okay, what's the evidence? Well, there's some unfortunate evidence in the prior public meetings where certainly there were people in the audience who were saying things, everyone understands this. The decision not to allow this was made because of the nature of the occupant. Then the town loses. And there was talk. The meetings, I look at them as problematic for a jury to look at and say that was not a factor. So you have to decide, we have to look at it. The best we can do is tell you what the likelihood of winning or losing. And looking at it, we thought there was a greater likelihood of losing than winning. Judge Bowl reviewed everything. She, I think, was even stronger.
Okay.
So you have to look at it and say, this is what you're walking into. You can talk, you walk into a jury going into a room and coming out, and the danger of a huge verdict against the town is real. We could also win, but that's what everybody has to weigh.
I will make some editorial comment. I sat in on every single one of those meetings, and the hue and cry was not about the structure of the building. And I'll leave it at that.
Yep.
Okay, Mr. O'Neill, do we have anybody else on there?
We do. Caller with the last 4 digits, 2008.
Hi, can you please give us your name and address, please?
Yes, my name is Janice Sawyer, and my address is 58 Lawrence Street.
Hi, Ms. Sawyer. What's your question or comment?
Well, I have 3 questions. One of them, and I asked this before at various meetings, but have never heard it answered. At any point in this process at all, including in mediation, was any kind of a land swap or a land deal offered as a reasonable accommodation to the applicant at all? And if so, did he just refuse it as an option? My next question is, tonight's vote, is that going to be a simple majority or a super majority? And my other question is, if this is voted in, is there going to be a list of conditions similar to you had attached to the previous application that would address issues like when they can work, hours, trash, you know, all those other kinds of special conditions that they would have to adhere to. And part of the reason I'm asking that is because I remember that when you were reading them the last time, I remember thinking that if I was in a butter, I would have been very upset about the Sunday morning time that you were allowing them to be on the property working. And then the last is my comment is I'm really feel for the members of the zoning board, you know, particularly those who feel like they are really being pressured. And this is my personal opinion, but I think it's important that people consider that the town manager and the Board of Selectmen have really left you guys hanging out to dry. And that's it. Thank you.
Thank you, Mrs. Sawyer. I'm gonna address the first question. I take you had 3 questions, and I hope I'm not wrong. One was whether there was ever any discussion of a land swap. The second one was asking what's the majority that's needed for this vote, super or regular, and then if there's going to be any list of conditions that may be put on anything that we vote on tonight. The first question with regard to the land swap, I'm going to address to Attorney Keston, because I think at some point there may have been some discussion about a recycle center or something. But then the other 2 questions I'm going to address to Jonathan, because you know he's our town council and he can probably talk about them. So, so Attorney Keston, you know, was there ever any discussion regarding a land swap in this particular case?
I believe, based on what the stuff I attended, and Greg attended a lot of them as well, there was an exhaustive look at any other possible location, and it just wasn't feasible, right, Greg?
Yeah, that's right. Members of the town looked at potential sites. There was some discussion, and then in the end, there just wasn't, I think, a practical site that could work.
Okay. I mean, was anything ever formally proposed or, you know, vetted with the other side? I mean, I don't know. There were
a number of sites that were sort of conceptually raised and discussed, but nothing that I think came to the point where it looked like something that was going to be a viable option.
Okay.
On both sides, I understand.
Can I just comment on that? From what I recall was that question did come up and it was answered, and I believe that the plaintiff that wasn't an option. They didn't want to do that, from my recollection, because they wanted the spot that they wanted. But somebody can refute that, but that's what I recalled.
Yeah, I'll just throw in that during and after the mediation, I know that both the town manager and the town planner had a printout of every town-owned property and went through it one by one to try to find something that would be appropriate. And some land was identified near the recycling center, and for obvious reasons that wasn't something that the plaintiff was willing to agree to. And you know, we have to be careful not to get too deep into the specifics of what happened at the mediation, but I recall Judge Bowl being particularly displeased when that was even mentioned.
Displeased with the town?
Yes.
So we're clear.
For offering a trash center for a rehab, I can't imagine why. Okay, Jonathan, how about the simple majority versus the supermajority question and regarding the questions? What's the conditions? Excuse me.
So the as I mentioned, the the statutes we're talking about deal generally with government actions broadly. They don't specify particular types of government actions, particular board votes. So again, I look at that Department of Justice and HUD guidance that says the board should use its normal procedures. Most of what the board does, not everything, but most of what the board does requires a supermajority vote. And I think the conservative view would be that because of that, your quote unquote normal procedures would include a supermajority vote. There are certain things you do that require only a simple majority, such as a comprehensive permit. And so I think there's an argument that could be made that only a simple majority vote is required. I have found no case law that addressed this issue. It would only really come up in Massachusetts because it's Massachusetts that has this somewhat quirky zoning act that requires supermajority votes. But as I said, my conservative view is that a supermajority vote would be required. I think Mr. Bobrowski may take a different view, but that's the answer I can get. There's no clear-cut answer.
Okay, so your belief is that it's a 4-to-1 that's needed for this to prevail.
I think that is a 4-to-1 vote clearly would prevail. There's an argument as to whether a 3-to-2 vote would prevail or not, but I think since there's no clear legal guidance on it, I would look at the DOJ and HUD guidance as suggesting you follow your normal procedures, which would typically require a supermajority vote.
Okay, and then the last question, I believe was Mrs. Sawyer. She asked if we're going to be attaching a list of conditions similar to the last relative meetings that we had, a number of them, or if this is just going to be a straight up vote on the accommodation. Do you know, Jonathan?
So I believe there was a list of conditions that, and Mr. Bobrowski can correct me if I'm wrong, I believe he submitted with his request for accommodation, and it was a list of conditions that was based upon the conditions discussed at the when Mr. Barletta made his original motion on the special permit a year or so ago.
Are any of them different from that particular motion that Tony Barletta made?
Well, I think some of the conditions weren't entirely fleshed out. It was obviously a motion that he made orally, and I can't tell you word for word. I think there might be some distinctions. There are some things that I think were rendered.
I guess what I'm asking you, Jonathan, I believe the vote. I believe the question that she was asking was, the vote that we take tonight, is it going to be basically just to grant the accommodation, period, or is it going to be grant the accommodation with a substantive list of conditions that were outlined previously?
I think the latter, but I think the conditions were submitted in writing with the accommodation request, and I don't have the actual accommodation request up in front of me. I can look for it, but Mr. Bobrowski.
That's fair. So the actual the accommodation request, which was made to the board, which is a public record, has the conditions within it, which have been available for the board to review. And when we make our vote tonight, it will be based on just the accommodation as submitted. Correct?
That's right. I just brought it up in front of me. I know that the list of conditions, I believe, was submitted with the motion to the court, but I would defer to Mr. Bobrowski and Mr. Keston or Mr. Pagnini on that.
Okay. All right. Well, I guess I'll ask you just, Mr. Keston, do you have the answer to that question readily available?
I think Greg does.
Yeah, my memory is that, and Attorney Bobrowski, correct me if I'm wrong, that it was appended to or incorporated into the accommodation request that you had made.
Which was what I thought. So when we grant the accommodation request, we're granting it subject to the conditions attached therein, which everyone has had privy to be able to look at and review and that ferret and everything else.
Mr. Chairman, there are 15 such conditions attached to the accommodation request. And in fact, correct me if I'm wrong, it's been more than a month now, but I believe the planning board actually attached these conditions to its approval of the reasonable accommodation request.
Perfect. Because you know what? In fact, I'm glad you brought that up, because I have the planning board's recommendation, which before we close, I'm not gonna read it into the record because it's single spaced and about 5 pages long, but I'm going to reference it. It will be made part of the record, and it does have those conditions as you outlined. So thank you, Attorney Bobrowski. Okay, Mr. O'Neill, anybody else?
No, not at the moment.
All right, well, we'll give it about, I'd like to give it about 20 or 30 seconds. There may be a lag in the delay and all this stuff, so. We'll just
Dan, I have a question.
Yeah.
I guess Jonathan was at the planning board meeting, and my question is on that. When the planning board.
Hold on, Ray. Okay. Before I let you go off, because we could be talking for 15 minutes.
Okay.
I want to handle the public hearing.
Mr. Chair, we do have a caller, last 4 digits, 7874.
Okay. Hello. Can you please give us your name and address?
Yes, Mr. Chair, it's Representative Robertson over in the other side.
Hi, Dave. What's your question or comment?
Well, I appreciate. I wanted to follow up. I know with the land swap that I had heard discussion before. What other land was offered other than the recycling center as a measure of goodwill towards the applicant around the area? Are there other parcels that were offered, or was that the sole one?
Well, is that your only question? Because if you have another one, ask it now, because I'm going to kick it back to these folks.
Yes, Mr. Chair. And that's the case. If it was not, indeed, what was the judge's reaction to that measure of goodwill from the town to try to work with the applicant to place it? Because, as everyone knows, it's location. That's the issue, not the use. So I'm interested in that and what the judge's reaction was from our counsel.
I will tell you this, Dave. I know that you're not really allowed to talk about what happens at a mediation. I mean, I know what happened at the mediation. I think other people here know what happened at the mediation, but I don't think it's prudent to talk about it. I will direct your question to whoever can answer it, and I would probably put it to either the manager or I would put it to Attorney Keston as to what specific properties other than the recycling center were offered up as a potential swap to the petitioner.
Greg, I think that was the only one, right?
Yeah, so that was the only one. I'll go back to something that Attorney Silverstein had said a little bit earlier, which was that the town made a great effort. I think it was members of the Board of Selectmen and town manager to go through and try to identify any town properties that could be a possibility. And the one that was identified was the one that was mentioned. And I guess to the question about how it was received, my own editorial comment would be that it was not received well. And I'll leave it at that.
All right, so I guess the answer to the question is that the trash center was the one that was presented, and we'll leave it at that. Okay, Attorney, Mr. O'Neill, anybody else?
Not at this time, no.
Okay, again, I think there may be a lag with the technology, and I'm reluctant to just cut it off. So I'll wait, another few moments here before I close the public hearing. Okay, going once, going twice. The public hearing is now closed. Thank you, Mr. O'Neill. Now, I'm going to kick it back to the board for discussion, deliberation, or anyone who cares to make a motion?
Dan, I just have a question on the planning board meeting. Were they aware of the that this didn't?
Oh, you know what, Ray, I hate to hold on. I hate to interrupt you again, but I just want to state this for the record. This is a housekeeping measure. There was a letter from the planning board that was submitted, and I'm pulling it out now. Jackie, what's the date of that planning board meeting? Help me out here. I just want to get it on the record.
What do you mean the planning board?
I mean, not Kelly. I mean Kelly. Sorry. It's been a long night already. Hold on.
Kelly, help me out.
Yeah. Kelly, what's the planning board recommendation? What's the date of that?
I'll have to look that up. It's in the folder.
I will state this. There was a planning board recommendation that they unanimously voted to approve the site plan, and they had given a 4 or 5 page letter with their recommendation and the conditions. And I'm not going to read it into the record. I'm just not going to do it. But it is part of the public record. But I will say that they did unanimously approve at their last meeting to approve the site plan with the conditions. So Ray, back at you.
Dan, can you just look up on the board? I think there's 2 callers right there waiting to be weighed in first.
I closed it.
Okay.
I closed it. I can't be doing this. We'll be here till 3
Oh, no, I'm just, what just came in. On the question I have on the planning board meeting, where this is coming in for accommodation on the change of the zoning, was the planning board aware that this did not meet zoning at the time when they held their meetings? Did that ever come up, and was that ever answered to them, or did they answer why they sent it forward, or did they just dump it in?
Well, hold on, Ray. I do want to Mr. O'Neill's telling me that there have been no callers for a couple minutes. So I don't know where you're getting your information, but our IT guy said
someone just texted me, said there was a couple calls been waiting.
No, I don't know. That's your text messages. But Mr. O'Neill just sent me an Insta chat and said that there have been no callers for a few minutes now.
Okay.
So maybe that's your private phone. So go ahead.
Yeah. On the planning board meeting, where this is calling for a accommodation of one of the requirements of the zoning change where it doesn't meet zoning. Was the planning board aware of that it didn't meet zoning, and how did they? Do you know how, Jonathan, how they actually handled that, or did they just say we approved the plan subject to the Board of Appeals approval on that zoning?
I mean, I will say it's a planning board issue, but Jonathan, you're here. If you were there, if you can answer Ray's question, go for it.
Sure. My memory is that they did recognize that the plan, in order to make the changes to the plan that were intended to respond to some of the concerns raised by members of the board, in order to address those concerns, they brought the building forward, creating the issues you raised, and that they viewed it as an improvement to the plan, and therefore approved the plan as an accommodation as requested by the applicant. Again,
I think what we're missing here, though, I'm asking the question on zoning.
Yeah.
When we first started the meeting, I asked if we are voting on a zoning change, and the answer was yes. And I believe that it didn't meet the bylaws of the town. So I was just wondering, where the Board of Appeal, the planning board held their meeting, do they have to deal with that phrase or not?
No. So again, maybe it's helpful if I sort of explain. Lenny and Greg can jump in if they want. The way that laws work in the United States is the highest law in the land is the U.S. Constitution. Then come federal statutes. Then comes the state constitution and state statutes. And beneath all of those are local bylaws, okay? So here we have a federal statute that trumps any local bylaw. And the federal statute provides for accommodations. So we've already talked about whether or not this is an appropriate accommodation. There are differing views on that, but you've heard from the attorneys representing you in the federal court litigation as to their view. So assuming that, yes, this is an appropriate request for an accommodation under federal law, then you're dealing with that request for an accommodation under federal law. And the fact that there might be a local bylaw that would otherwise be inconsistent with that doesn't alter the fact that you have to follow federal law before you follow state law. So this isn't rezoning. This is basically saying the request that's before you is to determine that you should not apply your local zoning in order to provide a required accommodation under federal law. So that's what's in front of you. And I know Lenny and Greg, if you want to add anything to that.
No.
No, I think you got it.
Okay, anybody else on the board care to make any comment or have any question of anybody? Come on, Jackie.
I know. It was kind of like winding up there. You know, hopefully I can say this eloquently enough. You know, with the building, working with plaintiff, they were meeting our certain, you know, requests and improvements. The building currently looks a lot more amenable to the area. You know, coming a little bit forward, it's kind of, it was a, you know, something to help the neighbors in the back. You know, it was kind of like a middle ground, which is nicer. I mean, I just got up again and looked at all the plans. You know, currently the plans that are in hand, I think are fine, or better than what we originally had. You know, I think it was nice, however that's the right word, that plaintiff is actually willing to do so many of the items that we asked. I think there was ample amounts. So we had a list. I mean, I don't have them in front of me right now, but there were many. The police, fire departments, they're, you know, they're working with the company, that's going to be having the building and everything. That there was a lot that they worked with the town. I understand the neighbors' concerns, but at the end of the day, my feeling is there's reasonable accommodation, and if you want a motion, I will create a motion right now.
Hold on, before you put it in a motion, is there any other member of the board that wants to add to the discussion, and then I'll entertain a motion?
So I just want to say a few words, Dan, about all of this. You know, talking about the threat of litigation and all of that, I mean, litigation, being sued is not a pleasant thing, as you were aware of. It will also affect my position in the federal government. But putting that aside, you know, I want to go in, if I'm going to be sued and I feel I have a position, I want my attorneys that represent me to feel that there is a equal acceptance of my position as well. So my concern is that I would be going in for lambs of the slaughter. If I had attorneys coming in and recommending that I have a weak case and they're going to take my case, I mean, come on. So, you know, with that in mind, that has nothing to do with this vote. For me,
Let me ask you, Tom. We've all been living this for like 2 or 3 years now. Have you ever heard any attorney tell you that the town had a good case?
No.
Well, I didn't hear you.
No.
All right.
So going into litigation for me to support me or Ray or anybody and try to win a case with my attorneys thinking I don't have a good case, how could I even possibly get through this? I mean, let's be real.
I have a hand up.
Go ahead, Attorney. Of course, Attorney Keston, go ahead.
I personally have tried over 150 jury trials, probably 125 of them on behalf of towns and boards. The job of your lawyer is to tell you the truth and to give you an honest assessment. If you want lawyers to always tell you you're going to win, even if they honestly think they don't, is that what you want?
No, that's not what I'm saying. I guess I didn't explain it to you correctly. What I'm trying to say is your position in this case, representing me, if I were to go in, would be foolhardy for me to even bother, because you're recommending that we don't have a case.
Yeah, and Lenny, and I wouldn't take that personal. And that's the reason I asked Ray the question. Has he heard from any lawyer or any judge, by the way, that we had a good case? And he answered, no lawyers. Ray, did you ever hear from any judge that we had a good case?
No.
All right.
And to be honest with you, I'm in the same boat as Tom. I feel that, you know, this is what the open meeting is, but unfortunately, behind the scenes, you know, the whole trend as that Mr. Keston just said, you know, he's coming straight out and saying, you know, the case is weak. And this is the general feeling that I've got out of 2 to 3 lawyers representing our behalf. So I don't have a strong feeling that anybody that's going to represent me, especially that I have to go, you know, and defend myself. If I don't have a good backing of a firm telling me that we have a solid chance, it's like Tom said, it's suicide.
Hey, Ray, did you go to the mediation? Ray, did you go to the mediation?
No, but I read all the reports.
Did you go to the mediation?
No, but obviously I was informed about it.
Tom, did you go to the mediation?
I did.
Did the judge think we had a good case?
Let me just answer this by saying this. The preparations on both sides of the case were like David and Goliath, okay? That's all I'm going to say about that. The second issue is her goal, I thought, was to get this back to the town with the attorneys to try to work it out. She came in as a mediator, and she tried to mediate this case, and she did a good job doing that. And I got the impression that she didn't want to, she could have said it was weak based upon what was submitted from our end and the plaintiff's end. I get that. But the bottom line was this. She was a mediator trying to get some sort of a decisive decision for both parties to go back and work it out. And she said, what is it going to take to work it out?
And in your opinion, did the petitioner bringing forth this project make any changes in furtherance of the judge's instruction?
No. What had ended was that if a drawing looked like something that was put up and shown, would I change, or would the mind of the board be changed? And I said, I don't know. And I'm not prepared to answer that. And she came back and said, okay, that's fair, basically. You got 30 days or whatever time to get back with me and try to figure this thing out, boys, and get back soon, because I'm upset about it and this should be worked out at your level. That's what I got out of this. What I'm hearing tonight was it was a weak case. It was a weak case. It was a weak case. And so, you know, that's not what I got out of it. And that wasn't the purpose of the mediation.
Okay. Anybody else care to make any comments before we entertain whatever motion Ms. Santini was prepared to make? Nobody? Going once? Going twice? Okay, anyone care to make a motion?
Make a motion. I'd like to make a motion to approve the accommodation as requested, subject to compliance with the board, with the planning board's decision and the conditions attached as Exhibit B to the motion for remand in the federal court litigation and referenced in the accommodation request.
Now, Attorney Silverstein, do you feel that that motion is properly worded for purposes tonight, or?
Sure. I'm assuming unless there are other conditions that you want to, that the board wants to impose, what that would do is incorporate by reference both the planning board's decision, which itself had a lot of conditions,
okay,
and the 15 conditions referenced by Mr. Bobrowski.
Okay, so understood. So Ms. Santini made a proper motion to approve the accommodation with the conditions included within the planning board site plan approval. Okay, we have a motion on the floor. Do we have a second?
Second.
I have a second by Attorney Barletta. I'm going to go down, and again, we have to go through roll call for all these votes. So I'm going to go through each member individually in the roll call to see if they go yay or nay for Ms. Santini's motion. I'll start off with Mr. Lepore, yay or nay?
No, no.
No. Mr. Siracusa?
Yes.
Mr. Barletta?
Yes.
Ms. Santini?
Yes.
And then myself, yes. All right, so we have a 4-to-1 vote to approve. So I guess the super majority was apparently reached. So I think that's it. All right.
Mr. Chairman, I thank you and the board for your hard work this evening, and we look forward to building a good project for you on Middlesex.
Please do what you can to mitigate any type of situation for the neighborhood. Okay.
We will do that. Thank you.
I appreciate that. Ms. Malatesta, do we have any further business before the board?
No, we do not.
All right, so I will entertain a motion to adjourn.
Motion to adjourn.
Ms. Santini made a motion to adjourn. Do we have a second?
I'll second.
Ray, we have a second by Mr. Lepore. All those in favor, I'll start off. Mr. Lepore, yay.
Yay.
Mr. Siracusa, yay.
Yay.
Mr. Barletta?
Yes.
Ms. Santini?
Yes.
And myself, yes. The meeting is adjourned. Thank you, folks. I appreciate it. Have a good night. Stay well.